Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour tour of Courtlandia. We will start in the 44th District, Royal Oak, Michigan. Magistrate Urich.
An informal hearing, true?
Correct.
So you heard the court instruct that you must select from one of three options to protect your rights. Yes?
Yep, yes.
Thank you very much, Mr. Robinson. The court is required to read the citation into the record, and then we will find out where we're headed. So this citation indicates that on April 5 this year at midnight, you were operating a 2021 Chevrolet black in color on Woodward Avenue, M1 at or near Webster City, Royal Oak. At that place and time, Officer Keikos discovered that your vehicle tag had expired on your birthday last fall. And at that moment, you did not have a physical proof of insurance to provide to the officer. So these are two 0-point documentary non-moving violations of expired plates and no insurance. You can admit responsibility. You can admit, explain, and display updated paperwork, or you can deny responsibility and we will conduct your trial forthwith. What do you wish the court to do for you, Mr. Robinson?
I will just admit to that.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with expired tags and no proof of insurance, yes?
Yes.
What's happening, Mr. Robinson? What would you like the court to know?
I would just like to accept it. So I had a court thing a few weeks ago with you, and I was up north for work, and I thought that this was the one. So I was caught off guard about this one today because I thought that was the one I did last week. And I showed you updated insurance and registration in that one. And I currently do not have mine on me because my car's in the shop.
Okay.
So I was wondering if there's like a possibility, since you saw it a couple weeks ago, if that could be still confirmed through this one.
Well, let's try to be patient for a minute. Stand by and I'll see if I can get that confirmed. Were you in some kind of delivery truck when that happened?
No, it was not a delivery truck.
Okay, no worries. Mr. Robinson, what do you got over there, Ms. Criffle? Okay, Officer Keikos, if it means anything to you, the registration and plate were renewed on April the 16th of this year. And ergo, proof of insurance was shown, so those cases had been dismissed.
I have no objection, Your Honor.
Motion to dismiss?
Yes, Your Honor.
These are gone, Mr. Robinson. Sorry about your vehicle being in the shop. And every April 9th, you'll know what to do for the rest of your life, okay?
Yep. That's
Good
sir.
luck.
Thank you guys. Have a good one.
Good morning once again, everybody. TCF Live on a Monday. Let's move along because we have more interesting things that have started to pop up now. It's like that on Mondays. Sometimes you start with nothing and then all of a sudden it's everything all at once. But let's go to Allegan County, Michigan. Judge Skocelas.
260037FY, People versus Caroline Evelyn Dial. Here this morning for arraignment, charged through a felony complaint that was issued by the Allegan County Prosecutor's Office on a charge of possession of methamphetamine.
I don't believe I'm privy to this. I think I may have been added by mistake. There are multiple people in the courtroom. Just wait for your name to be called.
Understood. I apologize.
Again, this is file 260037FY, People versus Caroline Evelyn Dial. Here this morning for arraignment charged through a felony complaint issued by the Allegheny County Prosecutor's Office on a charge of possession of methamphetamine. The Prosecutor's Office has also indicated she has a prior conviction for use of methamphetamine and is a repeat offender under the Michigan Public Health Code. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Ms. Dial for the limited purpose of arraignment. We reviewed the charging document and waive its formal reading. She does qualify for a court-appointed attorney, and we request that this matter be set for a probable cause conference and a preliminary examination. Thank you, Your Honor.
Now, again, this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from Thursday, which will be June 25th at 1 p.m. in District Courtroom D. Preliminary examination itself is the following the following Wednesday, that will be July 1st at 9 a.m. in this courtroom, District Courtroom A. Bail was originally set at warrant authorization at $1,000 personal recognizance. A bench warrant was issued for your arrest back on February 4th. Bond on the bench warrant was $5,000 cash or surety. Court file shows you posted a $5,000 surety bond. Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your next court appearance. Again, your next court appearance is a week from Thursday at 1 o'clock in the afternoon, so you are free to hang up in the court proceeding this morning, okay?
Yep.
I have 2 files on Reem, Raffek, Farah. Both files are based on the same appearance ticket issued by the Allegheny County Sheriff's Department on a charge of owning or possessing a dangerous animal and allowing a animal to run at large. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Ms. Farah for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. She's entering a plea of not guilty to the misdemeanor and is denying the civil infraction at this time. And we request, or she does to qualify for a court-appointed attorney. We request that these matters be set for a pretrial and a jury trial, Your Honor. Thank you.
On the criminal file 261501 SM, will enter a not guilty plea. Set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail on this file at $300 personal recognizance. Case to be set first for a pretrial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will be with you and discuss your case with you at the date and time of your next court appearance. Next court appearance on that file will be sent to you by the clerk's office in the mail. On the civil infraction, there is no possibility of any jail, and with that, the Public Defender's Office will not be representing you. However, I will enter a denial for you on that file as well, which means this case will also be set for a pre-trial conference with the prosecutor's office. You will be discussing this case with them personally. If this case is not resolved, it'll be set for a formal hearing also in this courtroom, District Courtroom A. Again, court staff will mail to you the dates and times of your next court appearances. With that, you're free to hang up in the court proceeding this morning, okay?
Thank you.
261449 FY, People versus Trevor, Scott, Kish. Here this morning for arraignment charged through a felony complaint issued by the Allegheny County Prosecutor's Office on a charge of home invasion in the 3rd degree. Prosecutor's Office has also indicated that Mr. Kish is a 3rd habitual felon. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Mr. Kish for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney, and we request this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
Okay, Mr. Kish, this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from Thursday, which is June 25th, and that will be at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, July 1st at 9 a.m. in this courtroom, District Courtroom A. Bail will set a warrant authorization at $15,000. Cash or surety, court file shows you posted a $15,000 surety bond. Bail will be continued in that amount at this time. Public Defender's Office has determined you are indigent and will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your next court appearance. Again, the next date and time of your case is a week from Thursday at 1 o'clock in the afternoon. So you are free to hang up from the court proceeding this morning. Okay?
Thank you, Your Honor.
252104 SM, People versus Gabriel Michael Moore, here this morning for arraignment charged through a misdemeanor complaint that was issued by the Allegheny County Prosecutor's Office and a charge of retail fraud in the 3rd degree. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Moore for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, and we would also like to address bond at this time as well, Your Honor. Thank you.
Would that be to go back or stay in Chicago?
Yes, Your Honor. He lives in Chicago and he also works in Indiana across the border as well.
Are not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Bail will set a warrant authorization at $500 personal recognizance. Will continue bail in that amount with the condition that you not be on the property of a Dollar General store while your case is pending. Will also indicate you may leave the state of Michigan while your case is pending. Your case will be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney for the Public Defender's Office will discuss your case with you at the date and time of your next court proceeding. Date and time of that will be sent to you with the clerk's office in the mail, so you are free to hang up from the court proceeding this morning. Be expecting that in the mail, okay?
Will that be at 3950 or 2559 Chatham Woods?
We're going to send it wherever you told us your last known address was when you were released from the jail.
Thank you. Understood.
Okay.
Alrighty, friends. Good morning once again. Let's move along. Let's go to Crawford County, Michigan. Judge Colin Hunter, I think he's about to do a sentencing.
To go over it.
No, Your Honor.
Mr. Thompson, do you have any corrections, additions, or deletions?
Your Honor, I think the prosecutor and I agree that the prior record misdemeanors on the cover face sheet at 0 is actually incorrect. And the prosecutor is suggesting 6. I don't object to that.
So I counted a number of misdemeanors. I didn't have the specific number, but Ms. Goki, you think there's 6 total that are listed in the PSI?
Yes, 2003 retail fraud and possession of tobacco, 2006 OWI, 2015 DV, 2022 impaired, and 2025 DV were all misdemeanors. So I had 6.
You think scoring was accurate, just not listed on the big sheet?
Correct.
You agree with that, Mr. Thompson?
I don't object to that, Your Honor.
We'll make that adjustment then. Do you have any other corrections, additions, or deletions?
No, Your Honor.
Do you believe the guidelines at 9 to 23 are accurate?
I do.
Ms. Goki, do you believe the guidelines are accurate?
I do.
Do you have other corrections, additions, or deletions?
No, Your Honor.
Do you have a someone else to help you?
She contacted us this morning and said she was sick.
And did you want to be heard?
I do.
All right, come forward, please.
You want to use the podium? You
Yeah,
can.
right to the podium, please. If you could say your name.
Jessica Elizabeth, Matt McNally.
Just McNally, I'm sorry, mispronouncing your name. Welcome. I'm glad that you're here. You have the right to be heard and to tell the court anything you think I should be aware of regarding sentencing.
I'm probably the spouse of Robert Emery. I have known Robert for over 20 years, and I truly am in love with the man. I believe he is an amazing, talented, incredibly smart man that can accomplish anything he puts his mind into. I truly believe I know this man more than anyone and couldn't be more ready for things to be different. We both are. I apologize in my part, in which has brought the reason upsetting him in the beginning. I should never have done it. Looking back upon our lives, Robert never really was an angry person until coming home from his stay in prison. He has been doing outpatient counseling at the Grace Center, but he really does need more. He needs to attend a long-term inpatient facility such as the Lion's Den. Therefore, I ask the courts to please give this deep consideration. This man and our family deserve a chance of the healing and freedom from so many bondages and bring peace. Instead of jail time where he sits and does nothing all day, in prison time to become even more angrier and have drugs be more available than on the streets, and where he still struggles with PTSD from, sending him back to this doesn't make sense to me. Therefore, I beg the court allow Robbie to take time to learn and how to live life on life's terms. And a life healed and forgiven, as I do the same. So we can not only be a best version for ourselves in each other, but for our children one day too. Thank you for your consideration.
Skocelas, on behalf of people.
Your Honor, the guidelines in this case are 9 to 23. Mr. Emery has a long criminal history. It involves alcohol and drugs and violence repeatedly throughout. This is not a person, this is his first time, violating the criminal behavior. This is his 10th felony. He's got 16 convictions now on his record, as well as a juvenile record. He has done poor on bond and poor on probation. That's all through his PSI. Community corrections is for people who want to do better. And if Mr. Emery had wanted to do better, Lion's Den has been available to him over and over. We hear from this court repeatedly that people want to go to rehab when they're faced with jail. This is not a facility for rehabilitation. This is a criminal court for punishment for your behaviors. I do think people deserve a chance. I have advocated for that. I've been the prosecutor here almost 10 years, and I have come in for people who need to get treatment program. But at some point, and usually I would say your 10th felony is definitely there, you have given up all of the opportunities you have by continuing violent behavior. Mr. Emery knew the consequences of his actions because he's done this over and over and over and over. I don't see the point in continuing to put him on probation here in our community and giving him opportunities that he didn't want to take. He could have gone to Lion's Den long before this offense happened if he thought he needed it. He could have gone while he was on bond. This case has been pending for some time here now. He didn't do any of those things. I think the court needs to sentence him within the guidelines. I think a prison sentence is appropriate. I don't think continuing our community resources on somebody who clearly does not want them unless he's faced with jail as the only other option is appropriate. So I'd ask the court to send him to the MDOC and a sentence of 18 months. Thank you.
Thank you. Mr. Thompson, on behalf of Mr. Emery.
Thank you, Your Honor. Ask the court to consider Ms. McNally's comments. Mr. Emery is a person with a lot of potential, a person who's trying very hard and has a very supportive partner. Unfortunately, Mr. Emery's case is one where he's been struggling with substance abuse, Your Honor. Criminal justice system. He ended up in prison and he's still dealing with PTSD from that. And he feels horrible about how he reacted that day. I know Ms. McNally apologized for upsetting him, but Mr. Emery understands he's going to be upset in the future, that his partner's going to do things that upset him. That's part of any relationship. And he understands that he has to do better. He wants to do better. And that's why I think the day after he's arrested, he's been contacting me about being in Lion's Den, about getting help, about turning his life around, about being the husband that he wants to be for Ms. McNally. And he is very motivated, Your Honor. And he has contacted Lions Den, and he is preliminarily approved. And he is requesting that the court consider a blended sanction where he does some jail time because he understands he violated the law. He understands he can't do that. But what he really wants to do is to set the rest of his life up for a better path and a better course. He wants to go to Lions Den. He wants to achieve sobriety. He's been sober and he wants to continue that sobriety, and he wants, Your Honor, a chance to go to the Lions Den. And I disagree with the prosecutor that doesn't involve punishment. I mean, this is a person who's going to be, pulled away from someone who loves him, pulled away from his job and his life. But he wants to do that because he wants to make those improvements that he needs to, Your Honor. Thank you.
Thank you. Mr. Emery, was there anything that you wanted to tell me before I go sentence today?
I just hope that lengthy jail stay and Lions Den is something that we can do. I would like to be able to get home with my family. Another courthouse. This was an accident, Your Honor. I tossed the phone onto the nightstand, overshot it, and it bounced off the wall and hit her in the lip. You know what I mean? I thought before it got escalated any farther. I thought that I did what I was supposed to. I made sure her phone was there. I didn't mean for it to happen like this. I've been trying very hard. I got off drugs, and I'm scared to go back to the MDOC because there's so many drugs readily available. I don't want to relapse again.
Thank you, Mr. Emery. Here, Mr. Emery, at 39 years of age, being sentenced on your 10th felony with 6 prior misdemeanors, 2 of which were misdemeanor domestic violence, 1 of which you're on probation for assaulting the same victim. When you tell me that it was an accident, I disregard that statement altogether. Your statement is not believable because it's contrary to your sworn testimony under oath committed in domestic violence. Domestic violences don't happen by accident. This domestic violence didn't happen by accident. Any suggestion by you now that it did, again, is discarded by me. It's not believable. It's not accepted. It's contrary to the established proofs that you offer in order to evade higher punishments, which include habitual force. I always take into account Ms. McNally statements of victims. The fact that you throw yourself under the bus and apologize for angering Mr. Emery. He was angry because you were texting people from the past is not really considered by me as a mitigating factor. Which to me, as the PSI agent writes in the PSI, that this cycle, unfortunately, is continued in part because you will throw yourself under the bus and take the blame for what Mr. Emery did. I'm not here blaming you as a victim, but what I'm suggesting is that Mr. Emery isn't entitled to consideration because he is able to convince people that it's not his fault. Nobody has the right to touch you or hit you or throw things into your face and make you feel less. That's what happened in this case, and the PSI is abundantly clear about that. Mr. Emery, if you're 17 months sober, as you claim, Lions Den is not the place for you. If you're not, it's still not the place for you. Not when I look at the 10th felony conviction at the young age of 39. You've had a history of non-compliance with probation and parole, a history of returning to prison while on parole because you're possessing weapons and drunk driving. Now an alarming history of not including probation for domestic violence and guidelines in 2023. Now I'm not bound by those guidelines in any way. They're instructive to me, I have to score them, but they also represent a calculated basis for me to look at this sentence. They take into account your offense variables. They take into account your prior record variables. They're a basic starting point for the exercise of my discretion. And for an individual on his 10th felony who doesn't take responsibility for what he did and tells me it's an accident on the day of sentencing, my discretion becomes much more limited. I have it, but it makes me consider the fact that you don't take responsibility and there's a little chance of rehabilitation. And there's nothing you could say, Mr. Emery, even if I let you talk again, which I'm not going to do, which would walk back those comments in the context of them. What you said matters. What defendants say to courts matter, always. So the court finds that a sentence within the guidelines range is appropriate. If you want to get into Lions Den when you're done with the prison sentence, you can. Nothing that I will do will stand in the way of it. Nothing that Ms. McNally will do will stand in the way of it. And it will only benefit you if that's what you think you need to have benefits in this community. The court finds that a prison sentence is indeed warranted in this case. You will be sentenced to the Michigan Department of Corrections for 13 months minimum, up to 5 years maximum. You have credit for 35 days that you previously served. I'll order that you pay a crime victim assessment of $130, $325 court costs, attorney's fees of $350, and a $68 state cost. Those fines, costs, and assessments are due today. If you don't pay them within 56 days of today's date, a 20% late fee gets added on. You do have the ability to ask the Court of Appeals for a leave to appeal for my judgment and my sentence. You can go through the appeal rights with your attorney. Mr. Thompson, do you have any questions or anything further for the record?
Not for the record, Your Honor. I just need to grab it.
Stoke, do you have anything further for the record?
No.
Just the no contact order?
The court is not issuing any no contact order or not continuing it. That's a fair question. I don't ever generally consider no contact when I send somebody to prison, but that's a fair question. I'm not ordering any no contact. To the extent there was any suggestion of no contact, I don't see that there was. I would not order it. I'm not ordering it. Okay.
Any initial? Right there, you agree for that. You're gonna take the bottom two copies of the lower section, look at what you fill out if you want without appeal. Yeah.
Are you ready, Mr. Holloway, Mr. Thompson?
Yes, Mr. Holloway's with us.
And I'm ready for Mr. Nelson, but he's not on yet. We're still a few minutes early. Mr. Holloway, you can come up to the podium, please.
All right, we'll check back perhaps with Judge Hunter in a while. Good morning once again, everybody. TCF Live on this lovely, lovely Monday morning. Let's go to the thumb of Michigan, Judge Prill.
Michigan versus Zachary Michael Grifka, file number 267465H. Time and date set for arraignment. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by prosecuting attorney Timothy J. Rukowski. Court notes in the information of the middle name is spelled M-I-C-H-E-A-L. Is that correct spelling of the middle name? Yes, sir. Okay, so that is your correct name. Zachary, Z-A-C-H-A-R-Y, Michael, M-I-C-H-E-A-L. Yes. Okay, thank you. Mr. Rooney, have you received a copy of the information that's been filed with this case? Have you and your client had the opportunity to view it? You wait.
Yes, so
Here's the plea, right?
there it is.
Mr. Grifka, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Mr. Rukowski, would you please state the terms of the plea agreement on the record?
Yes, Your Honor. Mr. Grifka may plead no contest to the charge of domestic violence, third offense, without habitual offender notice. People agreed to dismiss count 2, and the parties have stipulated to a sentencing range of 0 to 6 months. Mr. Grifka agrees to pay full restitution if applicable.
Mr. Rooney, is that your understanding of the plea offer?
It is.
Mr. Grifka, did you hear the terms of the plea offer outlined a moment ago?
Yes, sir.
Is that your understanding?
Yes.
And do you wish to accept it?
Yes.
Are there any other terms to the plea offer that we've not addressed on the record? Sorry?
No.
Thank you. Mr. Rooney?
I agree.
Mr. Rukowski?
I agree, Your Honor.
Mr. Grifka, are you on any term of probation or parole?
No.
Have you had sufficient time to speak to Mr. Rooney about this?
Yes.
Do you need any additional time to speak with him?
No.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No.
You have a clear mind?
Yeah. Yes.
Okay, I want to make sure you do. You have a clear mind?
Yes.
Okay. Sir, you are charged in the information with domestic violence third offense. That is a felony, and it carries a maximum sentence of 5 years in prison and or a fine of $5,000. In addition to that, you're subject to court costs, state minimum fees, crime victims' rights fees, probationary fees, or all of that. Do you understand that?
Yes.
Understanding the charge and the maximum sentence, Mr. Rooney, how does your client plead to domestic violence third offense on or about March 2nd of this year in Port Austin Township?
He's pleading no contest and faces his potential civil liability.
Is your plea no contest? Sir?
Yes.
Any objection to a no contest plea? Again, Mr. Rukowski?
No, Your Honor.
It is a proper basis. We can proceed in that fashion. Court is in receipt of an advice of rights form. It's dated June 15th, dated today. Mr. Clerk, can you sign this document?
Yes, sir.
Before signing it, I'm assuming you read it over. And you went over it with Mr. Rooney as well?
Yes, sir.
You understand the rights contained on the form?
Yes, sir.
By pleading guilty, no contest, you're giving up those rights. Do you understand?
Yes, sir.
Means you will not have a trial of any kind or have any opportunity whatsoever to contest your guilt. A no contest plea is tantamount to you admitting your guilt, and all that remains after today will be for you to be sentenced. If this plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you to plead no contest?
No, sir.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing the sentence. Do you understand that?
Yes, sir.
Does anyone promise the court will be easy on you? Does anyone threaten you to enter this plea? This plea of your own free choice?
Yes, sir.
Court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that?
Yes.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Are you aware of that?
Yes, sir.
Finally, if this plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal for the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand that, sir?
Yes, sir.
Any question regarding any of your rights? Any questions of Mr. Ruby? All right. Court is in receipt of defendant's proposed exhibit number 1, which appears to be a Port Austin Police Department incident report, incident number 26-33. Mr. Rakowski, any objection to its admission for a technical basis?
No, Your Honor.
We'll review it. 6 seconds. Parties had a child in common, Mr. Ruby?
They do.
Mr. Grifka, do you acknowledge being previously convicted of domestic violence in the 73B District Court on March 2nd, 2022? And also on June 30th, 2022, in the same court, 73B District.
Yes, sir.
Are you sure about that?
And I can't remember the dates exactly now, but
All right, do you recall 2 convictions in the 73B District Court for domestic violence upon self?
I was charged once, but because the first one wasn't, I was charged immediately. I'm pretty sure it was because I was admitted to a psychiatric hospital.
Understand. Mr. Rudy, do you, or Mr. Rakowski, do you have any information on the second? Other than what's listed in the information?
I could show you the
If you just want to read that portion of the record.
Sure, Your Honor. Well, I show on February 3rd of 22, pled guilty to misdemeanor domestic violence. On June 30th of 22, he pled to a domestic violence second offense.
Okay. You contest that, sir? You do? No, you don't contest. Okay. All right. Mr. Rakowski, where are the promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Mr. Rooney? No, Your Honor. Has the court complied with the court rule concerning pleas, Mr. Rakowski?
The court has.
Mr. Rooney? I agree. Mr. Grifka, there's no agreement made by this court concerning the plea and what the final sentence will be. Is that accurate?
Yes.
Mr. Rooney? I agree. And Mr. Rakowski?
Yes, Your Honor.
The court will accept the plea. It's done freely. It's voluntary understanding. The court had the opportunity to review Port Austin Police Department Incident Report 26-33, which was marked and admitted as Exhibit 1, indicates that the defendant and an individual with whom he had a child in common had gotten into a tussle over a cell phone, and that the other party, known as Ashley Marie Grifka, had been injured as a result. Court finds the essential elements of domestic violence have been established. Court will accept the plea and schedule sentencing for.
Your Honor, August 24th, I believe Mr. Rooney is going to be here that day for his other sentencing.
All right, so August 24, 2026 at 9 a.m. will be sentencing. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided to both counsel, report at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objections to the scoring of the guidelines must be filed in writing with the clerk of the court and probation within 7 days from sentencing. Defendant must appear in court at the time of sentencing. If either party wishes to provide supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was scheduled, John bond was set at $3,500, 10%. It's been posted. Mr. Rakowski, your position on bond, sir?
Your Honor, we have no objection to continuing bond.
Thank you, Mr. Rooney.
I'm asking the same.
Bond will continue to previously set. That will conclude the proceedings. Mr. Rooney, I will send you back to you, sir. That'll be all. We'll see you then in August.
Okie dokie, friends. Let us move along. We will stay in Michigan, but let's check in with Judge Elmore.
I have a couple of minutes to talk to him.
Sure.
I was just shown a police report or an incident report. I'd like to relay that to him.
All right. Well, I was just getting ready to call the case, but we'll go ahead and we will begin by not beginning and taking a break.
Thank you, Your Honor.
Thank you very much.
Or let's not start with with this case. Okie dokie, give me just a second because I did not have something else racked up. But here we go. Let's go back to Judge Prill then, new contestant there.
People State of Michigan versus Tyree, Donnell, Washington, 26-30-74-60-H. It's time of day set for arraignment. The defendant is present, represented by Attorney Michael Morosky. People are represented by Prosecuting Attorney Timothy J. Rakowski. Mr. Morosky, you acknowledge receipt of the information that's been filed in this case. Have you and your client had the opportunity to review it? Do you waive the reading, sir?
Yes, Your Honor. Mr. Washington, I reviewed it and waive the reading thereof here today.
Appears that there's a plea agreement. Is that correct?
Yes, Your Honor.
Thank you. As best you can, Mr. Washington, you don't have to raise it too high. Why don't you raise your hand a bit? Please raise your hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Rakowski, would you please state the terms of the plea up front?
Yes, Your Honor. Mr. Washington may plead guilty of possession of cocaine, 1 count of resisting obstructing by the Circuit Court of Arraignment. People have no objection to sentencing under MCL 333.7411 on the cocaine charge. And if he's otherwise eligible, people agree to dismiss count 3, which was I believe a second resisting obstructing count.
All right, but count 2 would be a straight vote.
Yes, Your Honor.
Okay. Morosky, is that your understanding of the plea offer?
It is, Your Honor.
All right. Mr. Washington, is that your understanding of the plea offer?
Yes, Your Honor.
And you wish to accept it?
Yes, I do.
Are there any other terms of the plea offer that we've not covered on this record?
No, Your Honor.
Ross?
I agree.
I agree.
Mr. Washington, are you on any term of probation or parole?
No, I'm not.
Have you had sufficient time to speak to Mr. Morosky about this?
Yes, I have.
Do you need any additional time to speak with him? Right. Anything affecting your mind or brain, making it difficult to make important decisions? No. You have a clear mind? I do, Your Honor. In the information, you are charged with 2 counts. Count 1 being possession of cocaine, which is a felony carrying a maximum prison sentence of 4 years and or a fine of $2,500. Count 2 is resisting obstructing a police officer, which is a 2-year felony, 2-year maximum prison sentence, and a fine of up to $2,000. Consecutive sentence may be imposed under statute if the assault was committed in a place of confinement or for another violation arising from the same transaction. Do you understand the charge and maximum sentence that can be imposed? I do. Understanding that, then, sir, how do you plead to those charges on or about May 2nd, 2026 in Bingham Township, Huron County, Michigan? Please guilty. All right. Mr. Washington, the court is in receipt of an advice of rights form dated June 13th, and it's signed by, here's me, Tyree, Washington. Did you sign this document, sir? Yes, I did, Your Honor. Now, before signing it, did you read it over? I did. And you went over it with Mr. Moronsky as well? Indeed. Understand the rights on the form? I did. By pleading guilty or giving up those rights, do you understand that? Yes, I do. Means you will not have a trial of any kind or have any opportunity whatsoever to contest your guilt, and all that remains after today will be sentenced. Yes, Your Honor. If these pleas are accepted, you'll be giving up any claim to these pleas the results of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim these pleas are not of your own free choice. Okay. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency? No, Your Honor. You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Yes, Your Honor. Has anyone promised the court will be easy on you? No. Has anyone threatened you to enter this case? No. Are these pleas your own free choice? Yes, they are. Court costs are due and payable at the time of sentencing unless good cause is shown. Are you aware of that? Yes, Your Honor. I understand. So you could be subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Yes, Your Honor. Finally, if you please accept it, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeals from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. You understand that, sir? Yes, Your Honor. Mr. Washington, any question regarding any of your rights? Any questions of Mr. Moronsky? Okay.
I thought you were asking him, my bad.
Oh, no, that's okay. Anytime, I always allow the defendant an opportunity to speak with his attorney, his or her attorney, anytime they need to. So that's why I always ask. All right, let's go back to May 2nd of this year. Were you in Bingham Township, Huron County, Michigan?
Yes, I was.
And did you possess something you should not have possessed?
Yes.
What did you possess?
Cocaine.
You knew it was cocaine?
I did.
It was yours?
Yes.
Where did you have it?
It was in my pocket.
Okay. For use?
Yes.
Okay. Was there a test done, Mr. Moronsky?
Yes, there was a true knock test performed and it came back positive for cocaine.
No objection to the court considering that, Mr. Moronsky?
No objection.
All right. He didn't have a prescription or anything. I know. I have to cover the bases though. For any license to have this type of substance, correct, sir?
No.
Okay. What happened with Eric Hessler?
He was driving the vehicle because I was too drunk to drive, and he took me from Unionville all the way to Bad Axe or wherever we were. And I told him to get out the car because it was a straight shot. I was resisting.
Okay, that was Officer Hessler?
Yeah.
And you knew he was a police officer?
Indeed.
He was in full uniform?
Yes.
Performing his duties?
Indeed.
He asked you to do something and you failed to do it, correct?
Yes, sir.
Any objection to the factual basis, Mr. Rakowski?
No, Your Honor.
Bronson?
No objection.
Mr. Rakowski, where have you promised threats or inducements for these pleas other than what's been disclosed?
No, Your Honor.
Mr. Bronson?
Correct.
Has the court complied with the court rule concerning pleas, Mr. Rakowski?
Yes, Your Honor.
Mr. Moronsky?
I agree.
Mr. Washington, there is no agreement made by this court concerning the pleas and what the final result will be. Is that accurate?
Yes, Your Honor.
Mr. Moronsky, do you agree?
I agree.
Mr. Rakowski?
Yes, Your Honor.
Court will accept the plea relative to count 2 in this matter. It's done freely, it's voluntary, it's understanding and accurate. There's a sufficient factual basis. As of count one, the court will take the plea under advisement because it's being considered under MCL 333.7411. However, the court finds that the plea there was also done freely, voluntarily, understandingly, and accurately. There's a sufficient factual basis, but we will schedule sentencing in this matter for
Your Honor, August 24th.
be a popular day. Morosky?
We will be available, Your Honor.
We'll schedule sentencing August 24, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided to both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. Mr. Washington must appear in the court at the time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set at $5,000, 10%. It's not been posted. Mr. Morosky, your position on bond.
Your Honor, at this time we ask for a PR bond. Mr. Washington has pled here today. He does live in the area. It's my belief he has no rampant history of missing court. He is gainfully employed, and this is strictly a monetary reason that he has been able to post bond. He doesn't have the cash or assets at this time. For those reasons, we would ask for a PR bond.
How many days has he been lodged so far?
It was 45 now.
45. He has no money to post at all. Nothing.
That's my understanding, Your Honor.
Mr. Burkowski, your position on bond.
We leave it to court's discretion.
He's still living at 505 East Clara.
That's my uncle's house. I was in the mix of moving to, I don't exactly know the address, but it's in C, but it's in Unionville.
In Unionville? Whom would you be living with?
His name's Cal. I can't remember his last name either. Pretty good friend of mine now. I'm poor with names. It's right by that gas station as soon as you get into Unionville.
Speedy,
Yeah.
Court will modify the bond to $500. I'm sorry, $3,500 per, strike that. $5,000 personal recognizance bond. However, before the defendant is released, we must be provided with the full name of the individual that he will be residing with and his address.
Okay.
The bond will be modified as soon as that information is provided to the court.
The defendant also instructed to contact probation office.
Yes, as soon as you are released on bond, Mr. Washington, you must go to the third floor here in the county building and meet with adult probation.
Okay.
Okay. Anything else for the record?
No, Your Honor, thank you.
Thank you. I have this question.
Go ahead.
I have another uncle that it'd be easier if I don't have Kale's number, but I contact my uncle Jamie. His name's Jamie Howell. He has a room I can stay in.
Would that be in Clara Street in Bay City?
That's my uncle Mikey. If I could do that address, that'd be better.
Well, we need to know where you're residing.
I could stay there at 505. That's Mikey Mazurowski.
505
East Clara.
Clara Street, Bay City?
Yeah.
All right. That was the address that was listed here in the information. But as soon as you're released from jail, you must meet with probation.
Okay.
Okay.
All right. Thank you, Your Honor.
You're welcome. That'll be it.
Okie dokie, friends. Let's head back over to Judge Elmore. Looks like that little side meeting is done, and we can give that a try again.
Ready, Nancy?
Yes, sir, I am.
All right.
Thank you.
Good morning. We are on the record now for the 28th Circuit Court here in Wexford County. We begin today's docket call by taking up the case of People of the State of Michigan versus William Forrest Maniche. The case number here is 25-14058FH. Appearances from counsel, please.
Joanna Carey for the people.
No, I'm Jeff Harrison. I'm here on behalf of William Maniche. As you've already indicated, he is appearing by video from the jail, Your Honor. It's my understanding he wishes to resolve this matter by making an admission to the allegations.
All right. Thank you. Mr. Maniche, can you see and hear us again?
Yes, sir.
All right. Also here before the court this morning is Mr. Kevin Stapleton. He's the agent from the Department of Corrections, serving as a probation officer. There we go. Sorry, I have a glitch on that. Mr. Harrison, is he pleading guilty? No contest? I see that one of them is an assault. So is there another charge?
I would prefer it be no contest in light of the fact that the jail has not yet concluded their investigation.
Oh, it allegedly happened within the jail?
It did happen within the jail.
All right, thank you.
And the people would be able to pleading to count one and dismissing count two.
That's fine too.
So you're gonna plead to the technical and dismiss the non-technical?
Correct.
Okay, Mr. Harrison, that sound good to you?
Sounds great to me. Thank you.
Figured it
Madam
was.
Prosecutor.
All right, Mr. Maniche, do me a favor, please, and raise your right hand. Third, you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
And lower your hand. Mr. Maniche, I'm going to remind you that you have a request and summons for probation violation here in this case. It alleges 2 counts. I'm told you're going to plead no contest to one of them, and the other will be dismissed. Now, a no contest plea has the same impact as a guilty plea. The difference is, instead of requiring you to state on the record what it is that you did that makes you guilty, I'm going to look at something else like a police report. Now, the benefit for a no contest plea is that whatever you say cannot be used against you if there's any criminal charge presented against you as well. And you can receive a new criminal charge, and it wouldn't be double jeopardy, because today we're really here only about whether or not you violated probation on your original case. It's not the same thing as being tried twice. Now, if you enter a plea here today, you're not going to have a hearing. You're going to waive the right to have the prosecutor prove the allegations by a preponderance of the evidence, which is a much lower standard than proof beyond a reasonable doubt at a criminal trial. You also will be given up the right to question, cross-examine any witnesses, and testify yourself or remain silent, so forth. If you're found to be in violation of your probation, you will be resentenced on your original offense. And originally in this case, you were convicted of unlawful use of a motor vehicle. And that is that the 2-year, right, 2.5. What was this then? Unlawful driving. It's a 2-year high court misdemeanor under MCL 750.414. All right.
Okay.
Mr. Maniche, you've got 2 counts. Count 1 is the technical violation, which is the better one. Now, they both have to do with assaultive, abusive, or threatening behavior. But count 1 is a violation of conditions 4.18. And then count 2 is a violation of rule 1 for violating a new law. I'm sorry, violating the criminal law. Count 2 is a non-technical, which means if you pled no contest to that count, then I would not have a limited sliding scale. But if you plead no contest to the technical, the most I can give you is up to 15 days. If you pled no contest to the non-technical, count 2, then I wouldn't be limited to 15 days. So if you understand, if you're tracking, that's better for you. Does that make sense?
Yes, sir.
Is that how you wish to resolve today?
Yes, sir.
Has anyone made any promises, threats, or inducements to force or compel you to plead no contest to this single count?
No.
All right, thank you. I need a police report or some kind of report.
There is I believe it's.
Or maybe there must be some kind of. All right. So, Mr. Maniche, I'm going to ask you how you plead in a moment. Remember, to get the benefit of not pleading guilty and not having your words used against you, I anticipate you're going to tell me no contest. As to count 1, Mr. Maniche, how do you plead?
No contest.
All right, the court has now been handed People's Exhibit number 1. It is a Wexford County Sheriff Incident Report, case number 83-2600755. And it consists of an initial 2-page report with a couple of supplements, and it looks like I see a total of 6 pages. Mr. Harrison, does the defense allow the court to use this to find taking a no contest plea?
Indeed, Your Honor, no objection.
Ms. Carey, do you believe that this, I'm sorry, People's Exhibit number 1 is hereby admitted. Ms. Carey, do you believe that this satisfies, has evidence to satisfy the required elements of proof in addition to the judicial notice for change of conditions of probation?
I do.
And are you aware of any other promises, threats, or inducements?
I'm not.
And do you believe the interests of justice permit the court to accept a no contest plea?
I do.
And do you believe the court's in compliance with court rules? Mr. Harrison, do you agree with all that?
I do, yes.
First of all, the court takes judicial notice of the terms and conditions of probation that are contained here in the court's file. Hold on, do we have prior technicals?
Yes, he does. There were two original accounts, then there was an added third for no show for.
Currently sitting on probation violations then?
Yes, sir.
Yes.
Oh, okay. So how many technicals has he had?
The two original technicals were of the same incident, so I think you count those as one.
Okay.
And then there's two, so this would be the third.
Mr. Maniche, that means that what I told you earlier was incorrect. The court could give you up to 45 days. I'm not going to say that's what I'm going to do, but the court could. Do you still wish to continue with this no contest plea?
Yes, sir.
Thank you. All right. I was in the process of finding when I signed the. Second. I signed it on August 11th, 2025, and it was subsequently acknowledged by the defendant on August 29th of 2025. Mr. Harrison, did you agree with Ms. Carey's responses? I'm sorry if I already asked you that.
Yeah, I did, Your Honor, and yes, you did. I don't mind answering twice at all.
Oh, good, good. All right, well, this court agrees and finds the defendant's plea today has been made freely, knowingly, voluntarily. The court finds the interest of justice do not require the defendant to reside a factual basis. The court also finds specifically that within People's Exhibit number 1, there's a page that's listed as page 2 of 3, which is within the original report, and that gives a pretty good description of the event, and that continues on page 3 of 3. Therefore, the court finds the defendant in violation of his probation and therefore guilty of count 1 on the request and summons, and count 2 is hereby dismissed. May we proceed to sentencing, Mr. Stapleton?
Your Honor, there's a couple issues. One is jail credit, very complicated because he's serving his sentence. He was sentenced at 365 on the previous violation, so he's being held until September, I believe, sometime in September.
Okay. All right, so you would like to do an update?
Yes.
And right now it's not hurting him because he's already serving that sentence.
That's correct. Yes, sir.
All right, thank you. Mr. Maniche, that means because you are currently serving a sentence and you're not going to be released until, when was that again?
September.
September?
Yes.
It's not going to cause you any prejudice. We're going to set this out for a sentencing that's going to allow Mr. Stapleton to prepare called a probation violation update. So we will be back here probably in another week or two. I'll say 2 weeks. One more. All right, Mr. Maniche, do you have any questions for me today?
No, Your Honor.
All right, thank you. Anything further, Mr. Harrison?
Nothing further, Your Honor. Thank you.
Anything further, Ms. Carey?
No, thank you.
All right, so again, we should be back here within the next 2 weeks or so. We are adjourned.
Morning once again, everybody. TCF Live on a lovely, lovely Monday morning. We actually here at the bunker had thunder and lightning just before sunrise, but it's turned into a beautiful morning. Let's go down to Florida. Wade Mercer.
I thought it was a felony, but this one
No,
is
sir.
showing it.
He has a misdemeanor driving suspended license charge. He was picked up on a warrant.
Okay, we'll call him in just a second, Mr. Kelly.
Let me make sure that we got to take care of Mr. Ricardo, our interpreter case first. Lieutenant, can you see and hear all the attorneys and myself? Wait, we'll get to it in a second. Okay. Lieutenant, can you see and hear all of us?
Yes, we hear you, Judge.
Yes, sir.
Thank you. We do have one interpreter case, and that is State of Florida versus Orlando Morales. Mr. Ricardo, good morning. If you please introduce yourself to Mr. Morales and make sure he can see and hear you.
Good morning, Your Honor. Señor Morales, muy buenos días. Yo soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Morales, good morning. You're here because you've been charged with one count of driving under the influence and one count of that. Is that the only charge? You also have a hold from the United States Immigration Service. So, Mr. Morales, I'm sorry. Go ahead, Mr. Ricardo.
Señor Morales, usted está aquí porque tiene un cargo de manejar bajo los efectos del alcohol y además de eso tiene una orden de retención de parte de inmigración.
You were first appeared this past week for the DUI, and you're being brought back today to try to see if we can resolve the case.
Tuvo la comparecencia inicial por el caso de manejar bajo los efectos del alcohol durante el fin de semana y se le está trayendo de vuelta hoy para ver si podemos resolver el caso.
I'm appointing the public defender's office to represent you. Please listen to your attorney.
Le estoy asignando la oficina del abogado de oficio para que lo represente. Por favor, escuche a su abogado.
Your Honor, I spoke to Mr. Morales. He's going to plead no contest to the charges listed.
Su señoría, hablé con el señor Morales. Él se va a declarar no me opongo ante los cargos, tal y cual se le acusa.
Understanding he's going to be sentenced to 9 days in the county jail, credit for 9 days.
Could you repeat for the interpreter, please?
He'll be sentenced to 9 days in the county jail, credit for 9 days.
Se le va a condenar a 9 días en la cárcel del condado con crédito por 9 días.
There'll be a fine of $1,078, which will be a civil judgment.
Tendrá $1,078 de multas como un fallo civil.
He understands that ICE will pick him up within 48 hours.
Él entiende que inmigración lo recogerá en un plazo de 48 horas.
He understands that any plea can be used against him in immigration court.
Él entiende que cualquier acuerdo se puede usar en su contra en el Tribunal de Inmigración.
Waive his right to a jury trial and call witnesses.
Ha renunciado a su derecho a un juicio con un jurado y a llamar a testigos.
Thank you. Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
Gracias. ¿Está de acuerdo el Estado, señor Mitchell? Lo está su señoría.
Mr. Morales, did you hear that agreement?
Señor Morales, ¿escuchó usted el acuerdo?
Sí.
Yes.
Sí. Y
Do
si
you have any
llega la,
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
sí.
Yes.
Okay.
Y si pago el 1,000, entonces yo voy a salir aquí o el ICE viene por mí.
And if I were to pay the 1,000, would I be released here or would I still pick me up?
No, you will not be released. Now, Mr. McDaniel's already explained that to you. I'm confident.
No, usted no va a salir aquí. Estoy seguro de que el señor McDaniel ya se lo explicó.
Whether you pay the money or not, doesn't matter. They have 48 hours to pick you up.
Si usted paga el dinero o no, no importa. Ellos tienen 48 horas para recogerlo.
Do you have
Está
any
bien.
other questions?
¿Tiene alguna otra pregunta?
Está bien que venga en 48 horas.
It's fine that they come
Yes.
for me within 48 hours.
Is this the plea you would like to enter?
¿Es este el acuerdo que desea aceptar?
Sí.
Yes.
Prefiero irme en mi país.
Yes,
And for the record,
I would rather go to my country.
for the record, there is no breathalyzer and no field sobriety exercises, and that's part of the basis for this sentence.
Y que conste en las actas que no hay un alcoholímetro ni tampoco ejercicios en el campo para probar su aptitud. Y esa es una de las razones por la cual se impone esta sentencia.
I want to accept your plea of no contest to the charge of driving under the influence with property damage.
Voy a aceptar su declaración de no me opongo ante el cargo de manejar bajo los efectos del alcohol causando daños a propiedad.
The judge is guilty of that offense and sentence you to 9 days in jail.
Lo condeno culpable del delito y lo condeno a 9 días en la cárcel.
Give you credit for 9 days that you've already served.
Le doy crédito por los 9 días que ya ha cumplido.
Impose court costs and fines of $1,078.
Le impongo multas y costas del tribunal por $1,078.
Is there a request to reserve jurisdiction for restitution, Mr. Mitchell?
Y hay un acuerdo para reservar el derecho de ordenar indemnización, señor Mitchell.
It was a single car crash into a sign, so possibly.
Fue un accidente de un carro contra una señal, entonces es posible.
Ms. Morales, the allegations are that you crashed into a utility pole causing damage to it.
Señor Morales, la alegación es que usted chocó contra un poste de utilidad causándole daños.
And if you enter this plea, I'm going to reserve jurisdiction for 60 days for the state to request restitution if they wish to.
Si usted acepta este acuerdo, voy a ordenar que se ordene indemnización en un plazo de 60 días si es que el Estado quiere pedir indemnización.
If they request restitution, you'd be entitled to a hearing on that issue within 60 days.
Si ellos ordenan indemnización, usted tendría derecho a una audiencia en un plazo de 60 días.
That does not change the jail sentence, nor does it change the immigration hold.
Eso no cambia la sentencia en la cárcel ni tampoco la orden de retención de inmigración.
Knowing that it's possible they would request restitution, is this still the plea you would like to enter?
Sabiendo que es posible que pidan indemnización, ¿sigue siendo esto el acuerdo que desea aceptar?
¿Tengo que esperar 60 días en la cárcel entonces o voy a esperar 48 horas? Perdón por la pregunta.
So I'm sorry for the question, but am I waiting in jail for 60 days or for 48 hours?
No, to clarify, the restitution possibility has nothing to do with the jail sentence. Everything else I said is true. They still have 48 hours to pick you up.
No, para aclarar, la posible orden de indemnización no tiene nada que ver con la condena. Ellos todavía tienen 48 horas para recogerlo.
Is this still what the plea you would like to enter?
¿Sigue siendo esto el acuerdo que desea aceptar? It's fine.
Have a good day, sir.
Estoy de acuerdo, 48 horas.
I'm okay with the 48 hours. Thank you. Que tenga buen día, señor.
De nada.
Perdón por manejar.
Thank you, Mr. What do you say, Mr. Ricardo?
I couldn't hear the last part. Fairly certain it said for driving, but the first part was I'm sorry for, and then sounded like driving.
He just apologized. Okay. Thank you, Mr. Ricardo.
Thank you, Your Honor.
So we do have Mr. Kelly's case. Mr. Kelly's case, the state of Florida versus the beat Mateen. Is he in the first appearance room, Mr. McDaniel?
Yes, Your Honor.
So Mr. Mateen, come on up.
Judge,
Mr. Mateen, good morning. Mr. Mateen, Mr. Kelly's appearing for you. I know that you can see and hear him. You're here because you're accused of one kind of failure to appear for the charge of driving while license suspended or revoked. Your fiance is in the courtroom. So listen to Mr. Kelly and we'll see where we go from here. I believe he's been first appeared and right now he's got no bond. Mr. Kelly, go ahead, please.
Judge, I'm downstairs, so I'm walking in as we speak. Mr. Mateen has a.
You just want to wait till you get up here, Mr. Kelly, and do it then?
If you wouldn't mind, sir, I'm walking into the courthouse now.
No problem. So Mr. Mateen, just have a seat. We'll call you back up in just a minute, okay?
Yes, sir.
So we do have one other person that has friends or family here, and that's Jeremy Wells.
Wells, yes.
Wells, good morning. Mr. Wells, your wife is in the courtroom. You're here because you've been accused of one count of driving under the influence and one count of refusal to submit to a breathalyzer test. Mr. Wells, I'm going to appoint the public defender's officer to represent you. I'm telling you, I did read the complaint this morning. There is probable cause for the charges. Please listen to your attorney and we'll see where we go this morning.
Your Honor, I spoke to Mr. Wells. We're going to plead no contest to the charges as listed. The understanding he'll be placed on DUI probation for 1 year, early terminate after 6 months. If he completes everything, $1,078 in fines, 50 hours of community service, minimum driver's license, suspension, DUI classes, alcohol classes if recommended by probation. It can be done through the DUI class, and that will resolve this case today. He has waived his right to jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Mitchell's had agreeable with the state.
It is, Your Honor. Did you see what the status of that refusal was, if he had a prior one?
Yeah, I told you he didn't have any prior.
He did it? Okay.
Yeah, that's happened a couple of times, Gary. You know what that is?
Yes, I will. So he hasn't had one?
There's no evidence of any prior DUI.
Okay,
at
so
all.
in that situation, I think that charge would just be 6 months to run concurrent.
Thank you. Mr. Wells, did you hear that agreement?
Yes, sir.
Is that the plea you would like to enter, sir?
Yes, sir.
Mr. Wells, I'm going to accept your plea of no contest into the charge of driving under the influence and the second charge of refusal to submit to a breathalyzer. Mr. Wells, I'm going to judge you guilty of the DUI. I'm going to withhold adjudication of guilt on the refusal. You got to clarify that on here. Place you on probation for the DUI for 11 months and 29 days. You'll have the standard conditions of probation plus the following special conditions: court costs and fines of $1,078. Successfully complete substance abuse counseling, 50 hours of public service work, and DUI school. As Mr. McDaniel said, you can sign up if you sign up within 60 days, then attending that class may take care of your DUI counseling. 6 months probation on the second charge, the refusal concurrent with the first. I already said withhold on that. No additional court costs and fines. Where do you live, Mr. Wells?
Tennessee, Your Honor.
Mr. Wells, you'll probably be doing what's called mail-in reporting, which means every month by mail or email, you can submit a form that the probation office will provide to you, and that will take care of your reporting requirements. If you don't send that in every month, that's just like you misreporting, Mr. Wells. Every probation case in Jackson County has a condition of no alcohol. Certainly a DUI has that, if it's an alcohol-based DUI. So, Mr. Wells, try to get everything done so you can get off early, like Mr. McDaniel said. Let me tell your wife what will happen next. So, ma'am, what will happen next is they will let him get dressed in his regular clothes. Then they'll bring him to the courthouse because that's where the probation office is at. It's downstairs inside the county judge's office on the east side of the courthouse, right down here. That's usually it's 30, 45 minutes. When he gets here, he'll meet with Mr. Goodson with the probation office. Mr. Goodson will go over the probation paperwork with him, give him a chance to ask any questions, give him all the rules in writing, and then he'll be free to go. So he'll be here probably 30, 45 minutes downstairs in the probation office. Do you have any questions? Mr. Wells, do you have any questions?
No, Your Honor.
I wish you the best, sir. Thank you for coming, ma'am.
Thank you, sir.
So let's go back to Mr. Mateen. And Mr. Mateen, you were first appeared, let me get back to that case number.
25161 CT.
25161 CT. It appears that in your first appearance, there was no bond, and it's based upon I believe I saw a written notice to appear given by the jail. That's what the no bond is based upon. You were given a written notice to appear to be here March 24th of 2025. And when you didn't show up, that's when the warrant was issued for your arrest, Mr. Mateen, and there's no bond on the case right now. Mr. Kelly's here, so we're going to see if we can make any progress and get the case resolved. So listen to Mr. Kelly, and we'll see where we go from here. Mr. Kelly.
Judge, I'm basing this off notes from some time ago, but my recollection is this is a case where he was on supervision up in Alabama. The discharge violated him. He turned himself in up there for the violation, and he had to do some time up there, which, if I recall, might have been the reason for the failure to appear. Judge, it's not a complicated case. We're trying to work it out with the state, but I think they were a little hesitant to do that because the court had already made an offer in the case. I just would like to try and work it out today if I could. I'd be happy to drive over whatever offer to the court, to the jail to try and resolve it so that we don't have to come back for another date.
Mr. Mitchell, what's the state's position?
What was he in? Was he in Houston County Jail this whole time?
No, sir. I'm not representing him. He was up there.
Okay.
He was up there, and then I think there was a work release after that he had to finish. But I can't represent.
Let me ask a question that may help here. So, Lieutenant, do you have show how much credit Mr. Mateen has in this case? In our jail? He may have some in another jail, I'm not sure, but in our jail, how much credit does he have?
5 days in our jail.
Okay, 5 days. And Mr. Mateen, did you come from another facility or did you get arrested here?
I got arrested here. I
Okay.
just was released.
Say that again, please.
I just was released a month and a half ago from the CCO in Dothan.
When you say CCO is, I don't know what that is.
I think
Is
it
that-
says city.
It's a correction in Dothan, Alabama.
Okay. And how long were you there?
I was there like 8 months.
Yeah, so if there's documentation that he was in jail when he missed a court date, Mr. Kelly, obviously that's gonna make me feel like he may be entitled to a bond. I don't know if he was or not. You may be able to get that documentation. The tentative offer made this morning in the public defender text before we realized that there was a private attorney involved was 30 days in jail because his history is so bad. His criminal history is not good. Let me make sure that's right. Is that what the tentative offer was?
Yes.
So we got a couple of options. If you want to talk to him and find out if he was in jail on March 24th of 2025, and there's documentation of that, then typically I'm going to set a bond or look at some release option as opposed to no bond. On the other hand, if you would like to take the 30 days in jail today, he's got 5 days credit. If you want to talk to him, that's okay too. Mr. Kelly said, I know that you're up here today.
I'll be happy to, Judge, I can't answer the question about the March date of whether he was in custody or not. Mr. Mateen, is that something you feel comfortable talking about, or do you want me to come over there in person, where it's not recorded?
If you could talk about, I said we could resolve it today if it's possible, some probation or something.
Yeah, your criminal history is horrible. You're not a probation candidate. Even without the failure to appear, you're not a probation candidate, Mr. Mateen. Your criminal history is probably 20 pages. So
Judge,
go ahead.
In light of the fact that he did serve a considerable amount of time, if indirectly on this case, is there any way the court might consider a 15-day sentence?
I don't know that he served any time on this case. You say indirectly on this case.
Indirectly
Help
for
me.
violating his probation up and.
Oh, yeah, okay. So I understand your logic. Well, the question would be, is this the sole basis for the violation? If he quit reporting or got 3 felonies in this, and then they send him to prison. So, and I don't know, I don't have a problem doing that. Mr. Mitchell, what's your thoughts?
I have no problem doing that either.
What if we did 15 days from now? That'd be a 20-day sentence, credit for 5. That'd be 15 days from now. He may do less than 15 with gain time, which I can't promise him, but he
Mr.
certainly may get.
Mateen, the judge is considering at least doing a 15-day, I'm sorry,
20 days credit.
20 days credit for 5, so 15-day sentence. Is that something you want to consider today?
Yes, sir. I consider that.
Okay. Is that something you want to do today?
Yes, sir.
You understand if you agree to that, you give up your right to go to a trial, right to call witnesses on your behalf, right to cross-examine the state's witnesses or assert any defenses that you may have.
Yes, sir.
Okay. I think you're probably making a wise decision.
Mr. Mateen, I also have to impose a standard court costs and fines. There'll be a civil judgment against you if you don't get them worked off at the jail, and you may get them worked off at the jail. Those court costs and fines are $400. Is that the plea you would like to enter? Actually, the court costs and fines are $300. What, did he ever have a public defender? He never had a public defender, did he?
I think he did. I'm representing at first and he didn't show up for
So the court costs and fines will be $400, but if you get them worked off, great. If not, it'll be a civil judgment. Knowing all of that, is this the plea you would like to enter, Mr. Mateen?
Yes, sir.
We're going to show a plea of no contest into the charge of driving while license suspended or revoked. I'm going to adjudicate you guilty, sentence you to 20 days in jail, but you have credit for 5 days you've already served. Court costs and fines are imposed amount of $400. Mr. Mateen, that means you have 15 days left at most. The reason I say at most is under Florida law, you certainly may get some gain time at the jail. You can get up to 10 days a month. So you could get a few days, do a few days less than the 15. That's between you and the jail. I can't promise you that. I'm just telling you it's possible. There's no probation involved in this sentence. When you finish this sentence, you'll be through with this case. The form you're signing now waives your right to a trial and waives your right to call and cross-examine any witnesses. Mr. Mateen, do you have any questions, sir?
No, sir.
In the courtroom, ma'am, do you have any questions?
No, sir.
So he's going to do probably somewhere between 10 and 12 to 15 days, depending on the program. You know.
Judge, would you like me to ride over to the jail and sign the plea form, or could I ask Mr. McDaniel to sign on my behalf?
Absolutely. We'll save you a trip over there. I think Mr. McDaniel probably, are you willing to sign on Mr. Kelly's behalf, Mr. McDaniel?
I just signed it. Mr. Kelly. So it's done.
Thank you,
He signed
Mr.
off.
McDaniel.
So, Mr. Mateen, there's no probation, sir. You finished this couple of weeks you've got left in the jail at most, and this is all over with. Do you have any questions at all, Mr. Mateen?
No, sir.
Mr. Mitchell?
Your Honor, he does have an open and pending civil citation for an improper left turn that stemmed from this incident. I don't know how you want to resolve that.
Mr. Kelly, typically, if there's a jail sentence imposed with a fine, I'm going to waive any other civil infractions with a few exceptions like child seats, stuff like that. So if you would like to plead no contest for the offense of
improper left turn,
I'm going to waive the points and fine on that if you want to do that.
All right, sir, the judge, you have an outstanding civil infraction for taking an improper left turn that you got at the same time. If you're willing to enter effectively a plea to that, the judge is willing to waive court costs in an adjudication, so you wouldn't get points on your license. Is that acceptable with you?
Yes, sir.
And Mr. Mateen, you don't have to do that. You can come back on a hearing solely on that civil issue, but if you want to resolve it while you're here, it'll be over with. I'm going to waive everything on it, points and fine, because you've already got the jail sentence imposed. Is that what you want to do?
All right, so I'm not getting no more time or nothing on that.
Oh, no, it's a civil, it's a ticket. I'm just going to waive the fine and waive the points. It's a ticket for improper left turn that you got at the same time.
I understand. Thank you. Yes, sir, that'll work.
So show a plea of no contest, improper left turn, waive the points, waive the fine. We're just getting rid of it so it's over with because you've already been punished from the same day and same time, okay? Mr.
Yes,
Mateen,
sir.
I wish you the best, sir.
Thank you.
Judge, exceptionally kind of you. And
Thank you, Mr. Kelly, for coming up and taking care of that. Thank you for coming, man. All right.
we had a little bit of confusion because his father had a felony case Tuesday that the names are very similar.
Are you on that case?
No, sir. No, sir. But we weren't sure that we were confused. And I became aware of that case this weekend and was not informed they were two different people until yesterday.
Well, thank you for coming up and getting that resolved today. So next case we have, I believe that's it for friends or family. So we can go back to the top of our list, Mr. McDaniel, which is Joshua Jones. Mr. Jones, good morning. Mr. Jones, you're here because you've been accused of one count of trespass. Mr. Jones, there is probable cause for the charge. I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I swear to Mr. Jones, he's going to plead no contest. He's understanding 10 days in the county jail, 1 day jail credit, $370 fine, waive his right to a jury trial and call witnesses that resolve this case today.
Mr. Mitchell.
that is agreeable with the state, Your Honor.
So I think this is the case where Mr. Jones might have been a probation candidate, but the last time he just never reported at all. And I thought, why set him up for failure? So that's why I came up with the 10 days in jail. So Mr. Jones, is this the plea you would like to enter, sir?
Yes, sir.
Mr. Jones, I'm going to accept your plea of no contest to the charge of trespass, adjudicate you guilty, sentence you to 10 days in jail, give you credit for the time you've already served, Mr. Jones. I'm also going to impose the court costs and fines of $370. Mr. McDaniel, I didn't write down the credit for time served. I know it was a weekend arrest. Does he have 1 day or more than one?
1 day.
1 day. 1 day credit. Mr. Jones, you have 9 days left at most. You may or may not do less than that. No probation involved in this sentence. The 370 will be a court call, I may have said 400, but it's actually 370. 370 will be a civil judgment if you don't get it worked off, and you very well may. Mr. Jones, do you have any questions at all?
No, sir.
Wish you the best, Mr. Jones.
All right.
We have LaChantel Brown next. Ms. Brown, good morning. Ms. Brown, you're here because you've been accused of, good morning, 2 counts of introduction of contraband into a state correctional facility, 1 count of possession less than 20 grams of marijuana, 1 count of possession of drug paraphernalia, and 1 count of contributing to delinquency of a minor. I've read the complaint. There is probable cause for those charges. Ms. Brown, I think you're entitled to a bond as far as I can tell, but I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
We just request you be subject to random UAs and have no contact with any FDOC facilities. As for the contributing to the delinquency of a minor, I'm not sure the best route for conditions on that. We'll leave it up to the court.
So, Ms. Brown, I'm going to set your bond at $5,000 each on the 2 contraband cases. Those are felony charges. The other 3 charges are misdemeanor charges. They'll have a $2,500 bond each. That means your total bond is $17,500 cash or surety. Ms. Brown, you've got a condition of random urinalysis, and I asked myself the same question about the contact with a minor, and I don't think it's the type of charge that I would be comfortable stopping contact with her daughter. Obviously, there's It's a serious allegation, but it is a misdemeanor, and the daughter's not really the victim per se. So I'm not going to put a condition of no contact with your daughter. I am going to do the random year analysis that's requested by the state attorney's office, and as well as the condition of no contact with any Department of Corrections facilities. You can't go visit anyone at Department of Corrections while this case is pending. Ms. Brown, you will get to use the phone in a few minutes, ma'am, to try to post the bond. If you post the bond, you'll be released. The jail will give you a notice for your court date, and that will be, I think it's still the 7th. July 7th at 8:30. They'll give you that notice in just a few minutes. Ms. Brown, do you have any questions?
No,
All right, Ms. Brown, wish you the best.
thank you.
Yes, ma'am. Next case we have is Krishanda Hordes. Ms. Hordes, good morning.
Good
Ms.
morning.
Hordes, you're accused of 2 counts of introduction of contraband, 1 count of possession of cannabis with intent to sell, 1 count of possession of cocaine with intent to sell, 1 count of possession of drug paraphernalia, and it's actually possession with intent to sell or deliver. Ms. Hordes, there is probable cause for those charges. The criminal history I've got is long, but it's under a different name. It's under Krishanda Much.
That's
So is
my
your
baby.
legal name is Hordes now?
Yes, sir.
Okay. So Ms. Hordes, I think you're entitled to a bond, but I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything?
That's Your Honor.
Mr. Mitchell?
Same conditions, random UAs and no contact with DOC facilities.
Thank you. Ms. Hordes, you've been to prison twice, is that correct?
Yes, sir, in the past.
Okay. Yeah. So what I'm gonna do is set you a bond of $7,500 on your felony charges. That's the contraband, 2 of those, the cannabis intent to sell or deliver, cocaine intent to sell or deliver. Your bond on those is $7,500 each. Your 1 misdemeanor is the paraphernalia. It'll have a $3,500 bond. Ms. Hordes, that makes your total bond $33,500 cash or surety. You have a condition of no contact with the Department of Corrections, as well as the condition of random urinalysis while you're on bond or while the case is pending. Ms. Hordes, the jail will give you a notice for your court date, and it should be July the 7th at 8:30. And you will get use the phone in just a few minutes, ma'am, to try to post the bond. Ms. Hordes, do you have any questions?
No, sir. Thank you.
All right, ma'am. Wish you the best, ma'am.
All right.
We've already seen Mr. Wells. The next case then is Carl Hendricks. Mr. Hendricks, good morning. You're here because you've been accused of 1 count of felony battery. Mr. Hendricks, there is probable cause for the charge. You have a very recent charge in the state of Texas, it appears.
No, I've never been to Texas.
Okay, that's
That's gotta
important
be a
because
mistake.
I may have a wrong criminal history. Let's see. Yeah, so Lieutenant, the criminal history I've got is on a Charles Hendricks, not a Carl Hendricks, and it's a different date of birth. I'm not sure how we got that. So I don't have any criminal history at all on Mr. Hendricks then, just that I've been provided. So Mr.
We can go
Hendricks,
pull one real quick if you want to wait on him.
I'm sorry.
We can go pull a new history if you want to.
Yeah, Mr. Hendricks, due to the nature of your charge, you may or may not be a conditional release candidate. So I need to know more about your criminal history. If you'll have a seat, we're gonna call you back in just a few minutes, okay?
I could volunteer that information if you like, Your Honor.
Well, I may need some details. So just have a seat. We'll see you in just a few minutes, okay?
Yeah, man.
Thank you. So we'll come back to Mr. Hendricks when we get a correct criminal history. That brings us to James Sims. Mr. Sims, good morning. You're here in case 26-195 CT. Mr. Sims, you're accused of 1 count of driving with no motor vehicle registration. I'm appointing the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Sims, and we were pleading no contest to the charges listed. You understand it can be sentenced 10 days in the county jail, credit for 10 days, $400 fine that resolved this case today. He has signed his two-way form with his right to jury trial.
So did he have some jail time on the front end before the Mr. Raymond?
I can look it up. He's been here 11 days though, so,
It was a purge offer, but he's already served it. It doesn't matter. Because I haven't been gone for 10 days. He must have had some time on the front end. Or in another jail, maybe. I don't know.
So was arrested June 5th, had a $400 bond, so it's been, today's the 15th, so it's 11th day, so he's been here 11 days. Okay, yeah, that's what I've got too. So what happens, he was arrested on the 5th, which was a Thursday or Friday, I don't know. All right, so Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Sims, did you hear that agreement, sir?
Yes, sir.
Mr. Sims, is that the plea you would like to enter?
Yes, it is, Your Honor.
Mr. Sims, I'm going to accept your plea of no contest into driving with no motor vehicle registration. Judge you guilty of that offense, sentence you to 10 days in jail, but you've got at least 10 days credit that you've served, so you'll be entitled to 10 days credit. This court costs and fines of $400. That will be a civil judgment. Mr. Sims, you'll be released today. As long as you don't have any holds anywhere, you're going to get out today. This case is over with, no form of probation. Mr. Sims, if you don't pay the $400 within 60 days, the clerk's office has to submit it to the state of Florida, and they will suspend your driver's license, so be aware of that. You also can enter a payment plan with them and don't have to pay it all within 60 days, but just be aware of that possibility. I don't want you to lose your driver's license through this. Mr. Sims, any questions?
No, sir, Your Honor.
Wish you the best, Mr. Sims.
Thank you.
Yes, sir. Okay, I believe next case we have is Tony Baxley. Good morning, Mr. Baxley. Mr. Baxley, you're here in two different case numbers, failure to appear petty theft in case 25-412 MM, driving while license suspended or revoked knowingly in case 26306 CT. In one case, you've got a bond. In one case, you don't. You're being brought back today to see if we can resolve your case, Mr. Baxley. Listen to Mr. McDaniel, and we'll see where we stand in these two cases. Your Honor, I swear to Mr. Baxley is going to plead of no contest to the charges as listed in the two cases. Understanding he's going to be sentenced to 60 days in the county jail. He'll have 10 days jail credit. They'll run concurrent. Case number 25412, he'll have a fine of $370. 26306T, he'll be a fine of $400. He has waived his right to a jury trial and called witnesses, and this resolved this case today. Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor, and there was a small amount of restitution in 25412 MM. It was only $11.70. We can make that a civil judgment.
So, Mr. Baxley, if you enter this plea, I'll enter a civil judgment for that $11 and some change. Mr. Baxley, any questions about that agreement?
No, sir.
Is that the plea you would like to enter to resolve these cases, sir?
Yes, sir.
Mr. Baxley, I'm going to accept your plea of no contest to two charges. Driving while license suspended or revoked knowingly and one count of petty theft. The case numbers have already put on the record. The judge, you guilty of those two offenses. Sentence you to 60 days in jail. $370 court costs and fines in the petty theft. $400 court costs and fines in the driving offense. The 60 days is concurrent. Credit for 10 days in both cases. So you've got one sentence of 60 days. Essentially, you've got one sentence of 50 days left. The restitution will be ordered in the amount of $11.70. That'll be reduced to a civil judgment. Mr. Baxley, you'll have time to work off the court costs and fines. Hopefully you will. If you don't, those will be a civil judgment against you. There's no probation to follow, Mr. Baxley. And Mr. Baxley, I haven't seen you in a while, and I do wish you the best. Sorry to see you under these circumstances. Mr. Baxley is the young man, when we were teenagers, introduced me to the wonders of a hot dog wrapped in a piece of cheese, put in a microwave on a paper plate. And I still have that as a snack from time to time. We called him Tony Baloney. Mr. Baxley, any questions?
No, sir. No, sir.
I wish you the best, sir.
Thank you.
Like, was it in a bun or what?
No, we couldn't afford no buns. We were too poor for buns. We just took a hot dog and a piece of cheese and wrapped it around it. And yeah, stay up all night playing Atari. Space Invaders and Atari. We have Judith Hamby.
I think she got returned to her cell. I think she's already been arraigned on the VOP.
Mrs. Hamby, I guess I'll just ask the court to go ahead and arraign her or assign me on her petty theft charge, because we've got to see her on the jail arraignment date coming up next month, July 8th, I believe it is.
So she's not in custody on that. Mr. Mitchell, do you have any objection to going ahead and appointing the public defender's office?
No, no objection.
So, Mr. McDaniel, I'm going to appoint the public defender's office to represent Ms. Hamby in 26296 MM. Mr. Goodson, anything in that case?
No, sir.
Thank you, Mr. McDaniel. Then that brings us to Brandon Quintana, I believe.
Yes, Your Honor.
Mr. Quintana, good morning. You're here because you've been accused of violating the terms of your county probation in case 25-500 CT. Mr. Quintana, I'm going to appoint the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Quintana. At this point in time, he's going to admit the validity of his probation. They're standing 60 days in the county jail, 13 days jail credit, whatever the remaining fine is.
Thank you, Mr. Goodson.
Yes, sir. He has a $268 fine. Can I ask you something real quick, Judge?
Sure. So, Mr. McDaniel, Mr. Goodson just wants to make sure he's getting his credit he's entitled to, which will be from when he resolved his case down there. So you're confident the number you've got is the correct number?
Yes, absolutely. It is. I give him credit for it.
Thank you. Mr. Mitchell, is that agreeable with the state?
Yes, Your Honor. What was the credit again?
13 days.
That's agreeable with the state.
And Mr. Quintana, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
I just had one question. I was locked up since May 6th, and I think they had a hold on me since May 8th. Or I was in the other jail. I've been in jail for about 40-something days now.
Yeah, you're entitled to credit from when you're released on the other charges, not when you're arrested, because you got arrested for a new DUI somewhere else. So part of that time you were in jail for their charges as well as ours. And if you post bond for their charges, or if you resolve their charges by plea, which you eventually did, then immediately you start getting credit for ours. So the credit Mr. McDaniel's calculated is 13 days. That's how long it took. That's how long you've been here, plus the amount of time it took us to get you from Bay County once they notified us and said he's resolved his local charges. So you agree that's the right amount of credit?
Yes, I understand.
Okay. Is this the plea you would like to enter?
Yes, sir.
All right. So I'm going to accept your plea of no contest, Mr. Quintana. Or actually, it's an admission that you violated the terms of your probation. It's not a plea of no contest. In case 25-500 CT, I'm going to judge you guilty of the offense you're on supervision for, which was reckless driving. I'm going to sentence you to 60 days in jail, but you've got credit for 13 days you've already served. Mr. Quintana also going to give you order court costs and fines that you have remaining, which are $268. Mr. Quintana, you have those days left to finish. You have no probation involved in this sentence anymore. You finish this sentence, this is all over with. You may have probation in Bay County. I think I saw probation in Bay County when I looked at the file. So when you get out, report to your probation officer there. But you're through with Jackson County probation, that is. Do you have any questions?
No, sir. Thank you.
Yes, sir. Wish you the best, Mr. Quintana. We have several violation of probation cases. I can see at the same time. Those are Andrew Wallace, Lisa McMahon, Benjamin Maxwell, Brian Taylor, and Fitzgerald Williams. So let's see. Andrew Wallace, raise your hand, please. Mr. Wallace and Lisa McMahon. There in the middle, we've got Benjamin Maxwell, right? Brian Taylor and Fitzgerald Williams. So I'm seeing you at the same time because your cases are identical for first appearance purposes. You've already been first appeared, but at that time, that judge didn't arraign you, probably because it was just someone covering for me. This is what I normally do is I go ahead and arraign people at first appearance if an affidavit's already been filed by the probation officer. And in your case, it has. That way I can arraign you. I can appoint a lawyer to represent you and get the lawyer started on your case, which is what we try to do. So what the question is, do you want an attorney to represent you? Mr. Wallace, would you like to have an attorney appointed to represent you, sir?
Yes, sir.
Great. Mr. McMahon, same question.
Yes, sir.
How do you say your last name?
McMahon.
Okay. Mr. McMahon, and same question, Mr. Maxwell, you want an attorney appointed to represent you?
Yes, sir.
All right. Mr. Taylor, same question. Mr. Williams, same question.
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you. Listen to Mr. McDaniel. He's going to give you a court date. And once he gives you a court date, we will see if you have any questions. Mr. McDaniel.
Your Honor, we're going to plead not guilty. As I said, this on July 9th court date. Advise them all, there'll be attorneys to come and visit them prior to that date.
Perfect. Mr. Wallace, any questions, sir?
No, sir.
Wish you the best. Ms. McMahon, any questions?
No, sir.
Wish you the best. Mr. Maxwell, any questions?
No, sir.
All right, wish you the best too. Mr. Taylor, any questions?
No, sir, Your Honor.
And thank you. Mr. Williams, any questions?
No, sir.
All right, wish y'all the best. The attorney will see you before your court date. We have Jacob Hutchinson.
Hi, guys.
Hutchinson, good morning, Mr. Hutchinson. You're here because you've been accused of one count of possession of drug paraphernalia. I believe you've been set a bond by the first appearance judge covering that day. I'm going to appoint the Public Defender's Office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Yes, sir. Your Honor, I spoke to Mr. Hutchinson. He's going to plead no contest to the charges listed. The understanding that he be sentenced to 60 days in the county jail, 3 days jail credit, $385 fine. He has waived his right to a jury trial and call witnesses. That'll resolve this case today.
Thank you. Mr. Mitchell, anything from the state?
No, Your Honor, and that is agreeable with the state.
Thank you. Mr. Hutchinson, did you hear that agreement?
Yes, sir, I did.
Do you have any questions about that agreement?
No, sir, I don't.
And Mr. Hutchinson, is that the plea you would like to enter?
Yes, sir, it is.
Mr. Hutchinson, I'm going to accept your plea of no contest to the charge of possession, drug paraphernalia. I think this one is, Mr. Hutchinson, you just got out of prison, correct?
Yes, sir, I did.
Yeah, that was a factor in the sentence. That's one of the factors we looked at. So I'm going to sentence you to 60 days in jail, accept that plea of no contest, 3 days credit, court costs and fines of $385. A judge you guilty, no probation involved. You finish the sentence, there's no probation involved. And the court costs and fines will be a civil judgment if you don't get them worked off at the jail, and you certainly may get them worked off at the jail, hopefully. Mr. Hutchinson, I wish you the best, sir. Any questions?
No, sir.
Have a good day, sir.
You too.
I believe we think we need to go back to who? I can't hear you both. I'm sorry. Carl Hendricks. Mr. Hendricks, let me get your paperwork back. So, Mr. Hendricks, we're seeing you again now that we hopefully got a criminal history on you. Mr. Hendricks, you're accused of one count of felony battery. I've already told you there is probable cause, and Lieutenant or Sergeant, what do we have on criminal history on Mr. Hendricks?
Your Honor, looks like last arrest was in 2020 for domestic violence. There's 2 domestic violence disputes in his history. Last arrest 2020, arrested in it's like 2015 for marijuana possession, 2003 for grand larcenies, marijuana possession 2008. None of these are in Florida. They're all in another state.
The
2000, hang on. Sorry. 2020 also some unlawful carrying of a weapon, drug charges, sale of delivery of a stolen pistol. Not convicted of that though, so that was something that was dismissed. The other domestic dispute was also in 2002. So 2020 and 2002, only things I see that are violence, any kind of violence.
Okay, thank you. Mr. Hendricks, just a couple of questions. Do you have any charges pending anywhere?
No, sir. And the 2020 domestic violence was dropped after I completed all of my classes and courses.
Okay. Are you on any
Okay,
probation anywhere?
No, sir, I'm not.
Mr. McDaniel, he's not a conditional release candidate with that history, but I think he's entitled to a bond. Anything else that you want to make me aware of, Mr. McDaniel?
I just maybe be aware that if he was not convicted of those, it'd be a misdemeanor. I don't know.
Your Honor, I do have a full-time job. I am the sole provider for my family. Like, I pay all the bills of the house. I understand that there's a no contact order. But I can't afford to pay a bond and get out and pay my bills. I got to be able to.
Great bodily harm. That's what
Yeah.
gallery.
Thank you, Mr. Hendricks. Mr. Hendricks, you're not a conditional release candidate with that history. You're just not. And Mr. McDaniel, he's accused of felony battery based upon the injury, not based upon the priors.
I apologize.
No problem. Mr. Mitchell, anything else?
No, Your Honor.
Mr. Hendricks, your bond's $5,000 cash or surety. That's a normal felony bond. I was set for that charge for anyone who has a prior history. That's not a horrible history. Cash or surety means you can go through a bondsman. You don't have to put up all $5,000. That's what a surety bond is. You'll get a chance to use the phone in a few minutes, sir, to try to post the bond. You do have a condition of no contact with the alleged victim, which I'm going to talk about in just a second. And the jail's going to give you a court date for your notice for your court date, which should be July 7th at 8:30. Mr. Hendricks, do you and the alleged victim live together?
Yes, sir. We've been together for 13 years. We have a child together.
Okay. So right now there's no contact. What that means is you cannot live in that home she lives at. You can only go over there with law enforcement at one time to get your clothing and other belongings you may need for work. Otherwise, you've got to go somewhere else. Don't go over there. If she wants contact and you want contact, it'll probably be dealt with at your next court date. There's probably going to be no contact between now and then based upon the injuries. The allegations are that she was struck with a phone and she had to have stitches in her forehead, I believe is what the allegations are. So, Mr. Hendricks, just no contact with her, at least for the time being. We'll cross that bridge in the future. If you both want contact, either myself or Judge Garcia will consider that. Mr. Hendricks, do you have any questions?
No, sir, other than the fact that she expressed that what happened wasn't intentional. And I expressed what happened wasn't intentional. I don't understand.
Yeah, that's not what the
how two
complaint
people
says.
can agree it's an accident.
That's not what the complaint says. The complaint says that you turn around, you threw a phone at her. What you said is you turn around and somehow the phone magically slipped out of your hand and hit her in the face with enough force to cut her, and then also with enough force to ricochet off her face and put a hole in the sheetrock. So that's the allegations that are in the complaint do not make it appear to be accidental. But we'll see what the state can do at that trial. I wish you the best, sir.
Yes, sir.
Are y'all here for a first appearance case, gentlemen? Okay. Mr. McDaniel, I think that's it on my list. Anything else I may have?
Is it just me, or is there a lot of violence involving a phone this morning? Monday, I guess. Good morning once again, everybody. TCF Live, good to have you all here. Let's go to Texas. Judge West.
You need to set that on the trial docket.
Did you do a rejection?
I think she's already done, because I'm the trial counsel that was appointed.
Has there been any change in?
No, ma'am. No, you're
All right, ma'am, you're Marquise Berry. And this is 25 DCCR 0882. And Ms. Berry is charged with aggravated assault with a deadly weapon. It's like back in March, there was a rejection of a 10-year term in prison. And you want to continue with that and go forward with trial with Mr. Radford. All right, we'll get it set on the trial docket. I do want to make sure, Ms. Berry, that you understand that after today, once your case is on the trial docket, I will not accept this plea agreement unless there's something that comes up that your attorney or the district attorney doesn't know at this point. Otherwise, if you change your mind, you can enter a plea open to the court or to some other plea agreement. Do you understand? All right, we'll get it set on the trial docket. Thank you.
Maybe.
Yes, sir. Aaron Shetley, Ms. Melfino, and Judge Walker. Morning. All right, so are you Aaron Shetley?
Yes,
and Mr. Shetley's case is set, it's a pre-trial, set trial to begin with jury selection next Monday. What is the announcement?
Judge, I have spoken many times with Judge Walker about this case. I know that it's obviously getting older on the trial docket. I had also let her know several months ago that I was likely to be out next week, and I let her know several weeks ago I will be unavailable for court. I apologize about that. We are still working toward a possible resolution that may involve a jury trial, but that's something that Judge and I would like to possibly discuss with you a little bit later. But that is my situation for my two trial cases next week.
Okay.
I asked that they.
And we left them on today just in case. We wanted
Yes,
to make
because
sure that there was anything that might get worked out. But if it's not going to get worked out today, any objection to that getting reset?
If she's not going to be here, we're ready.
Okay.
And I did let Judge Walker know.
So we'll just reset it on the next available trial docket. If something works out between now and then, please bump it up and so that we can get it taken care of before that date. Otherwise, we'll get it taken care of the next court day because it is definitely one of the older ones on the docket.
Thank you.
So-
And I've also spoken to the misdemeanor prosecutor who's handling that, and I
Okay.
think we'll try to take care of everything.
All right, stay in touch with Judge Walker. He'll let you know when you need to be back. Thank you. Yep. See, Mr. Rojas, are you ready on William Bonilla?
Yes.
Good morning. Are you William Bonilla? Good morning. This is, good morning, Mr. Rojas. Clause numbers 25 DCCR 0719 and 25 DCCR 0174. And what is the announcement?
Yes, I think our plan is to enter pleas to the motion, come back to the punishment hearing, and then after that, we'll see what happens with the felon in case.
Oh, okay. One of them's, are they?
Motion, it's a motion to revoke on a misdemeanor. Either the other.
So. And so what are you guys gonna do with the new case?
The motion's based on the new case, so depending on what you do with the motion, I think eventually we're gonna plead it, but I want to see what happens punishment wise on the motion before we do that.
Mr. Bonilla, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And thank you. Will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Bonilla, in clause number 25, BCCR 0174, I have a motion to revoke your community supervision. Shows that you were placed on probation April 14th of 2025 for the Class B misdemeanor of driving while intoxicated. That was a 180-day jail term that was probated for 15 months. Is that correct?
Sure.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. And is that true or not true?
Your Honor, before he answers, may I move to orally amend that count to read that the defendant committed the offense as opposed to was arrested for the offense, so that it lines up or matches the
Yeah,
the
that's,
MPRP or the
thank you.
conditions. No objection.
Okay. All right, so count 1 now alleges that you committed the offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. Is that true or not true?
Not true.
So we're gonna have to come have a hearing with,
It's just a matter of you watching the video, and that is all. But yes.
I mean, you'll have to have an officer come to
Yes,
prove it
yeah.
up. Have y'all watched the video?
I have.
Okay.
We have, yes. Yes.
Okay. Count 2 alleges that you failed to immediately report to the probation officer that arrest from May 10th of 2025. And is that true or not true?
Sure.
Did you enter your plea of true to count 2 freely and voluntarily?
Yes, ma'am.
And because count 2 is actually true? All right, then I'm going to find that you entered your plea true to count 2 freely and voluntarily, find that count true, find sufficient evidence to not find you guilty, to revoke your probation. I'm going to reset your case for sentencing. And it sounds like we just need, unless there's some agreement that if it's mainly just the video, if you guys agree that he can present the video without having an officer having to come lay that foundation, great. Otherwise, I would think still an 11 o'clock with just one witness would be plenty, correct?
Yes, ma'am.
All right,
Sure.
y'all discuss that, and then I'll get an updated pre-sentence report, and we'll see you back at sentencing.
All cell phones out of sight during the proceeding. Like, don't let me see them. You put that phone away.
They're recording.
I don't think so. They're not going to talk on.
Mr. Rojas, you have David Calderon. Good morning, sir. Are you David Calderon? And this is 24 DCCR 1428. Mr. Calderon is charged with unauthorized use of a vehicle. And what is the announcement?
Judge, we're asking for another announcement document. We do have a discovery in the offer. I have relayed an offer to Mr. Calderon. However, it was the wrong offer. Somehow my offers got mixed up in the file. So now
Okay.
we need more time to go over the correct offer and give him time to look at all that.
No objection, Judge.
All right, so I'm going to reset it one time. I know you were just recently appointed, but Mr. Calderon had to come here quite some time, so the case is very old. So if you can try to get with Mr. Rojas, make sure you go visit with him before the next court date so that we can get an announcement. All right, you're free to go. Amy, Carol, Mr. Rojas. Good morning, ma'am. You're Jamie Carroll. This is 26 DCCR 0286. Ms. Carroll is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I spoke with Ms. Carroll on briefly last week. We haven't had a chance to go over all the discovery. I can give you that announcement about the able to do that.
Any issue with something?
No, Judge, I've sent 2 alternative offers to Mr. Rojas.
So, Ms. Carroll, I'm going to reset your case about 30 days. You need to make sure and make an appointment to go visit with Mr. Rojas. So you can go over everything that he has, and we'll get an announcement at the next court date. Don't wait till right before that court date. Make sure you call him, go see him plenty of time before that, okay?
Yes.
All right, free to go. Gabriel Pena, Mr. Rojas. Good morning, Ms. French. Good morning. Good morning, sir. You're Gabriel Pena.
Yes.
And this is cause number 26 DCCR 0064. Mr. Pena, you're charged with the 3rd-degree felony offense of failure to comply with sex offender registration requirements. And that's from September 27th of 2025. Your indictment alleges that you were previously convicted of indecency with a child by exposure, 3rd-degree felony, December 2nd of 1999. That after that was final, you were convicted of failure to report a change of address, a 3rd-degree felony, May 22nd of 2014. Well, what that means, sir, is that if you go to trial and you're found guilty, The minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. I'm sorry, no, I don't. I have a document entitled plea bargain rejection. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that? Thank you. And so do you want to reject that offer and have your case set for trial? All right, I'll get that taken care of. Mr. Pena, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
That. Sure, I could. Answer that. Is it to my?
To your benefit? Is that what you're trying to ask? So it's really up to you. If you want to keep Mr. Rojas, then he can prepare for trial and get ready. Otherwise, I'll appoint a different attorney today and they'll get prepared. Mr. Rojas is just here a lot, handles a lot of cases, and a little busy, but it's up to you. If you want to keep Mr. Rojas, that's fine.
It's completely up to you. With your. Opinion.
It's really, yeah, it's really up to you. Mr. Rojas is fine either way. So if.
And we have a few minutes, maybe pop.
Yeah, sure. And you can just let me know and then I'll either. Y'all visit for a few minutes and then he can let me know what your decision is. Okay. I'm so sorry, excuse me. Deary.
Alrighty, friends, about to enter hour 3. There we go. Learn how to speak, Dan. About to enter hour 3 of TCF Live. Let's stay in the building. Go across the hallway, Judge Stevens.
Yeah, come on, Miranda. Come on. Thank you. How's it going in there? Good. All right. You know, we've been through this before. You know, you're on probation for criminal mischief, and probation office is here today with us. You were placed on probation last November 17th for criminal mischief, and that was for 5 years deferred. You were not found guilty, so that's a good thing. But now we've got a motion to revoke probation that has been filed alleging that you committed assault, bodily injury in December, which was a month after you were placed on probation, then failed to report to the probation office in December and February. Let's see, failed to provide verification of performing community service hours. A special amendment here, an additional one, you failed to submit to a mental health evaluation as directed by the court. What do we have to do that? Can we do that? Get that done while she's in custody? All right, that's what we're going to do, if you'd be so kind. So here's the problem is that any of those, if it's proven true, then your probation could now be revoked and you could be sentenced up to 2 years in the state jail. How much time has she already had? See, yeah, you can't enjoy being, but you want to get home, don't you? Me too. We're going to find out how much time for you have. So Mr. Adams is here, is your attorney. You've had a chance to speak with him, right? How's that going?
Good.
Good. You understand everything he says? Good. He's a smart guy. He's a smart guy. So now you can either, is there an offer that's been made to try to resolve this?
Yes, sir.
Okay. But let me ask you, do there's restitution involved here, right? It's criminal mischief. Restitution, how much is it? Or is there not?
I got on here, it says $3,150.
Is that from restitution or is that for just fees and other probation fees?
Well, they just, okay.
She doesn't have restitution. Oh, okay. All right. Well, you got that off your back. Have y'all tried to resolve it?
Yeah,
Under these circumstances, she's just sitting in jail.
The offer was 1 year. I tried to convey that to her. I don't think she understood that. And then I asked her about what happened with Orange, the case of Orange, and she didn't understand what was going on in Orange.
So what's going on in Orange? Do you have another case pending in Orange County?
I do not think so.
You don't think so?
She,
What,
because I
you
actually
found
wasn't
out?
disposed of, I was just still.
Did you find out? Well, so what's probation though?
I don't know anything. I just know.
Did y'all check on anything pending in Orange County that's above a Class C misdemeanor?
Yeah, she's arrested in Orange, December 18th for assault. She was staying at the Women's Center out there in Orange.
Oh, okay.
And she assaulted another, resident. And there she was released.
What do they say? But I don't know how fast Orange moves on that, but I would think if it's something like that, they would probably move quickly. But could y'all look and find out?
Yeah,
Into that? She's got 266. She's just sitting in jail, 266 days now.
Do you want to see this move case back? They forwarded it.
You know what we need is to find out
That's what.
that and also this Orange thing, what they're gonna do in Orange County. All that.
You don't know
needs to be
anything about
resolved.
it? Nothing about
No.
it?
Have you ever been evaluated for any mental issues before?
No.
No, never? Yeah. How far did you go to school? Did you graduate from high school? You did? Where?
Butter?
At Vider High School? And did you go to college or anything like that? Ma'am?
Sorry.
Okay.
See, that's what I was thinking, Judge, with the difficulty with being able to kind of communicate. And I was thinking it was more of a mental health issue, but that's what I want you to see for yourself.
I don't know. You're not Rapon and neither am I, but from the probation, the experience you've had with her,
I have never met her.
you've never met her. Okay. What was the problem? Going to the meetings, you had to report, or else you're not on probation. You're not on my supervision. I don't know where you are. So if you're not reporting, that's the first thing you have to do. Yes, ma'am. So what are we doing about that? You gonna try to do that?
Yeah,
I mean, we help you. We help fix things.
Yeah.
Well, you got a great sense of humor about it. I'll tell you that. And did you grow up in Vider area? And you've never been evaluated for any mental issues before? Yeah, okay. You're certainly taking all this well. Certainly find it amusing. Well, here's what I'd like. What do I say? Stand by. Dr. Perpond evaluated her.
Just saying,
And she's confident. He knows. You did this in Sims.
I just want you to see for yourself.
But we did it for a reason. We had that done because everybody, I'm sure, convinced me that she's taking this seemingly lightly and giggles a lot, which I don't find that a bad thing. But there's not a lot of giggling here in this room.
No, sir.
Except from the lawyers.
So then I can go tell my friends there's a woman hitting on me today.
Sit down.
Sorry.
I think she, like every other person on the planet, is just different. And it's not different to a degree that the man I trust would find her incompetent. She's just different. So we all are.
Well, that's true.
All right.
Absolutely true.
I don't, he evaluated her, but, and he always does a thorough job. She can understand the legal proceedings, has the ability to communicate with her attorney. Is not in need of involuntary inpatient psychiatric treatment. She did report some psychosocial problems because, and that she's something kind of like a transient, but is dealing with it. You know, all of this shows that she's unique, different, but that doesn't mean that she's incompetent.
That's true.
Or mentally ill. So we're going to stand by this, since this was just a few months ago. With this evaluation. So what can we do? Try to resolve this motion, because, or instead of her hearing from me, but she's on deferred or unadjudicated probation. Is there something, and these are, the thing that I guess is the elephant in the room is what's going on with the case of assault in Orange County. Can we?
I'll follow up with it.
I'm gonna give it 1 week to just to check.
I come back anyway, so how about
Thank you.
Monday?
We're gonna reset this 1 week. Okay,
Perfect.
Miranda, thank you. Get you rolling on this. Tyrell Hopkins.
Let me get into.
Oh gosh, what are we gonna do? It's a motion to revoke probation as well.
Yes, Judge.
From the judge, that's fine.
Is that right? Look at this indictment. Oh boy, we got priors. Priors. Robbery.
Judge,
Mhm.
on Mr. Hopkins, almost that. No, over here.
You're Mr. Tyrell Hopkins.
Yes, sir.
Yeah, here in clause 22-39026, there's a motion to revoke unadjudicated probation for unlawful possession of a firearm by a felon. You were placed on 10 years deferred of unadjudicated probation. It's a few years ago now. This is going on 4 years. Anyway, this states they filed this because you failed to report to the probation office. This states on or about October 21st, the year was 20,225. We gotta fix that. Did I miss something or did a few years pass?
Yes.
Okay. And then November 3rd of 2025, which was more or less realistic, December, January. So you were missing these monthly and you weren't reporting, which is the most important thing to do is to report, or else you're not on supervision, which is what this is all about. And people think that's not important, but it is the most important thing. There's nothing we can do to help fix this mess that you got yourself into because of you're in attendance. I'm looking at 1988 robbery conviction in Michigan. Then you have the illegal possession of a firearm, and it states that you have that conviction out of another conviction out of Oakland County for illegal possession of a controlled substance back in 2010. So you've got that 88 robbery, then the 2010, and then now this new charge, which is a third-degree felony in paragraph 1. But because of paragraph 2, that robbery conviction, the way they pled it, this third-degree felony is enhanced to a second-degree felony. So you're looking at up to 20 years in prison if convicted. All right. And you're not eligible for probation in front of a jury if you try this. So where are we on this?
Just where we were, I know the offer was 4 years, but I believe we came to court on the 1st. And I think the motion to revoke hadn't been filed yet. And I think he reduced his bond to $10,000 because he reduced the bond. And I believe the state has filed the motion to revoke what he said on 3rd, right? The 3rd or 4th.
Yes, this was filed on June 3rd.
It was filed on June 3rd after our court date on the 1st. So I guess where I am with him right now, Judge, is
what you want to do today? It's early, but he's sitting in jail. There's ought to be something y'all might be able to work out, but maybe not. I don't know. I just want to give you a few weeks to do that.
That's perfect. We'll try to put it together.
2 weeks good?
Perfect.
Yeah, okay. Let's see where we are, sir.
Okay.
Sir?
Personal crimes bonds?
No, sir. Not when you're looking at this. These multiple charges from the past and now. And you're looking at the failing to report.
I reported, Your Honor.
This, well, the state says you didn't on October 21st, November 3rd, December 5th, January 6th. Which they're monthly reported.
I was in a rehab. She knows this.
Well, it's not, this isn't the hearing on the debate.
Sorry.
Judge, it was my understanding from speaking with probation that he was ordered to go to safety after the administrative hearing and then did not report to safety, which is why we went ahead and filed the MTRP.
That what happened?
Yes.
Okay, why didn't you report to safety?
Because I take certain, like I was telling you, and then she told me it was 6 months to go to St. Pete, right? And then I was informed that until you take that medication, you can't just do 6 months. You would have to do 6.
Who told you that? Who told you about the medication?
Everybody knows this.
Everybody?
They says.
Oh, these people are giving
you do 9 months of St.
medical
Pete.
advice to you who you don't know?
It's a law that you got.
I know what the law is.
It's 9 months of St. Pete plus 3 months.
I know all of this.
Plus 3 months and a halfway house.
Now, I know that here's the problem. Once again, is you failed to report, which is the most important thing to do. That's what this states, and that's what this hearing is going to be all about. Is your failure to report on all these months. That's since October. I mean, you were essentially, we call that an abscondence. You were on your own probation, which really shouldn't be. You're supposed to be supervised. And if you don't report, you can't be supervised. It's the most important thing. That's why it's always, I mean, in your probation order, you remember receiving that. Report is directed right at the top. You're supposed to report at least every month. And we had to go find you somewhere. And that's what this hearing is all about. When can you do it? All right.
Thank you, Judge.
Jesse Mason.
Yes, she should be right up.
Alrighty, friends, hour 3 of TCF Live. We will keep an eye on this courtroom, but let's head back up to Huron County. Judge Prill has a new contestant.
Packet file number 267403FH. Time and day set for sentencing. This packet is present, represented by Attorney Michael A. Morosky. People are represented by Prosecuting Attorney Timothy J. Rakowski. Back on April 13th of this year, the defendant entered guilty plea to operating while intoxicated third offense, as well as lying to a police officer. Ms. Karen Evelyn has prepared a pre-sentence report dated May 27th of this year. Mr. Morosky, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions, deletions, corrections, or objections other than guidelines?
Nothing of note, Your Honor.
Any objection to the scoring of the guidelines?
No objection to the scoring of the guidelines.
Ms. Peck, do you agree with both of those?
Yes.
Mr. Rakowski, any objections to the report as well as guidelines?
No, Your Honor.
Thank you. Mr. Morosky, what would you like to say on behalf of Ms. Peck before the court imposes sentence?
Thank you, Your Honor. Ms. Peck has had no involvement with the criminal justice system in approximately 10 years. She has been on the sober link since this incident. She does live in Grand Rapids, and she has no violations.
She has immense family support. She's gainfully employed. The guidelines here came back at 0 to 11. You know, we understand under statute, she has to serve at least 30 days. At this time, Your Honor, we'd ask that Ms. Pack be sentenced to 30 days in the Tarrant County Jail with the other 150 days held in abeyance at this time. Thank you.
You're welcome. Ms. Pack, is there anything you'd like to say?
I was just really dumb that day.
Your bodily alcohol content of 0.162. You recall that, correct?
Yeah.
And when confronted by police, you gave the police officer your daughter's name.
Yes.
Mr. Rukowski, anything you have to people?
No, I would have just pointed out what the court just did. So based on that, we ask you to adopt the recommendations that's recommended.
All right. The defendant comes before the court 62 years of age, no prior felonies, but 6 prior misdemeanors. The court already brought up the blood alcohol or bodily alcohol content. It will be the sentence of this court, the defendant be placed on a term of probation for a period of 3 years. Conditions of probation include the standard conditions. Not to violate any criminal law of any unit of government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. She's not to use or possess any alcoholic beverages or other intoxicants nor enter bars or other places for the primary purpose is to serve alcohol for consumption on the premises. Please. She's to comply with requirements of alcohol and drug testing as directed by the field agent, follow all the rules pertaining to that. Not use or possess any controlled substances unless duly prescribed by a licensed physician. She's not to be around anyone that possesses those items, nor is she to possess or have around her any drug paraphernalia. She complete any outpatient or residential substance abuse treatment when referred by the agent. She is to complete a substance abuse assessment when referred by the agent. She's to waive confidentiality and allow me treatment program that provides services to provide disclose that information to the agent. She's to comply with the DOC's electronic monitoring program. 480 hours of community service will be ordered. No assault, abusive, threatening, or intimidating behavior. No verbal, written, electronic, or physical contact with anyone housed within an MDOC facility, nor the same type of interaction with anyone engaged in behavior that constitutes a violation of any criminal law of any government. She's not to use any object as a weapon or own or have or control, use or area control a weapon of any type, cannot possess an imitation weapon, cannot be around anyone that possesses those items. She is to contact the supervising field agent no later than the first business day following her release from jail or placement on probation, that is. She's to comply with all written and verbal orders of the agent. She's to allow the agent to her residence at any time for probation supervision, where she's subject to a search for personal property, including but not limited to a home vehicle or computer without the need of a warrant. If the agent has reasonable cause, she has items that violate the terms of her probation. 24-hour rule will apply regarding any arrest or police contact, loss of employment, or change of residence of the reported to the agent. She's not to operate a motor vehicle while her license is revoked. The Secretary of State will take appropriate license actions. Crime victims assessment of $130 will be ordered. Probation supervision fee $30 per month regular, $60 electronic. Court cost of $150 payable at the rate of $10 a month. A fine of $500 payable at the rate of $15 a month. Attorney fees are waived. DNA testing fee of $60 will be ordered. $68 in state costs will be ordered. Probation is authorized and empowered under statute to effect their apprehension, detention, and confinement of up to 72 hours on reasonable cause she violated the terms of her probation. And if referred, she must successfully complete any PA 511 programming based upon eligibility. She shall also serve 180 days in the county jail, credit for 2 days previously served. In count 2, lying to a peace officer, court will order a fine of $100 payable at the rate of $10 a month. No court costs will be ordered. $68 in state costs will be ordered. All court cost obligations are due by August 10, 2026, or be subject to the 20% penalty. It's my duty to inform the defendant she has right to seek leave to appeal. If she's financially able to provide counsel of her own choice, court will assign counsel for her expense. She's to initially receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Court has no objection to PA 511 status nor any objection to work release, so long as it comports to the Huron County Sheriff's Department guidelines. Defendant is remanded in custody of the sheriff. That is all.
Alrighty, friends, let's stay in Michigan, but let's go over to Wyandotte to say good morning to Judge DeSanto.
Good morning, Your Honor. Edward Holmberg on behalf of the defendant. I am standing in for the attorney of record, McDarren. That's with your permission, correct, Mr. Hess?
Yes, sir.
Okay, and counsel, your P number for the record, please.
62763.
Okay, very good, thank you. And sir, your name for the record, please.
Colby Hess.
Okay, and so today is the date scheduled for the arraignment pretrial in this matter, and we did select today's date with a time of 8:30. I believe that your attorney had another matter he had to appear in for Third Circuit Court. We were just having some internal challenges as far as getting some things moving this morning, so I do apologize for that, sir. And so, counsel, as to the pretrial in that matter, thank you.
Yes, Your Honor. We've come to a resolution where the defendant is responsible for being going the wrong way, one way, an illegal turn, not changing your address. Is that correct?
Yes, sir.
Okay, and then that's on the civil infraction, and then the 457 A, B, and C.
Be dismissed.
I show that's going, there's going to be a double parking on that one.
Yes, sir. I'm sorry.
Okay. All right, sir, well, your attorney worked out an extremely generous resolution for you, sir.
Yes, ma'am.
All right, please raise your right hand. You solemnly swear or affirm the testimony about to take in this matter to be the truth, the whole truth, and nothing but the truth.
That's right.
Okay. And you have heard the pleas that were placed on the record, correct?
Yes, Your Honor.
As to, let's take the civil infractions first. Being driving the wrong way on a one-way street, how do you plead?
Guilty, Your Honor.
Responsible or not responsible?
Responsible.
As to failing to change address, how do you plead? Responsible or not responsible?
Responsible.
As to the amended charge on the 26457A B and C matters, the amended charge of double parking, how do you plead?
Responsible, Your Honor.
You've gone over your advice and rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, administrative agency.
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
All right, and the court will accept the pleas as knowing and voluntary. Dismiss the interfering with public safety officer, open intoxicants, no insurance. And sir, on the double parking, that's going to be a $200 fine. On the driving wrong way on the one-way street, I believe that's $90. Alicia, can you let me know what that is? And I do not know what the fine is for fail to change address.
Okay.
When you have a moment, please.
We'll be able to pay that today as well, Your Honor.
Okay.
Failure to change address is 85. And driving one way is 105.
Oh, okay. All right, so that's $190 on that matter. And then $200 on the other matter, so a total of $390. You can pay that today, sir?
Yes, Your Honor.
Okay, very good. All right, stop at the window, sir. Somebody will be with you shortly.
Thank you very much.
You're welcome. Have a good day.
Thank you, ma'am.
Okay.
Alrighty, friends, let's go back to Texas Judge Stevens again.
Kendall, relax. Good. Relaxing is doing all the damage duties, right?
Not bad, Hey.
It's taking over. That's right. Are you Jesse Mason, sir?
Yes, sir.
In 26 CR 446? Hello. Okay. You're charged with the state jail felony of unauthorized absence from a community correction facility. Was this one of those things where he was released for visitation or something? And since he left the center as intentionally or knowingly leave said center as directed by the court and the community supervisor and without the accomplice approval of second order. Right. What? So then in there while he was required as a condition of community supervision. Required as a condition of community supervision, required as a condition of correctional programming. I know that doesn't make sense. To submit to a period of detention and treatment in a community correctional facility, namely Beaumont Center. And you intentionally or knowingly left said center as directed by the court and the community supervision correctional. That doesn't make any sense. And without the approval. So it says that he intentionally or knowingly left said center.
Judge, I
As
agree
directed. I'm just reading the indictment.
yes, I agree that the wording is interesting and the facts on this are a bit unique. I believe that the indictment is alleging that he was supposed to be in the center as directed by the court and community supervision, and without approval of the court and community supervision, he left the center.
Well, that's not the way it reads. It
Yes,
says
we can,
intentionally or knowingly leave said center as directed by the court. I didn't direct him to leave.
no, Judge, we can get that fixed.
Yeah, the wording's bad on this, sir. We're trying to, first thing is, it doesn't matter until the indictment is fixed. That's the most important thing. Everything flows down from the allegation, and the allegations. It's alleging up at the unauthorized absence, but the body is confusing and it needs to get cleared.
Yes, Judge, we will go right on that.
The thing is, you've got those 3 prior convictions in January of 22 for out of Gregg County, which are terrible things. This is a state jail felony, but if all of these 3 convictions are true and you're convicted of the correct wording that was intended based upon the offense as alleged, then this would be a state jail felony, though punished as though it would be a 3rd degree felony. It gets enhanced 1 level because of the 3 prior convictions. And the thing that helps you on that is that these were 3 convictions on the same date. So you can't stack them because they weren't in sequence of dates. But it's still a state jail felony punished as a 3rd degree felony. So you're looking at up to 10 years in prison, which is never a good thing. And you're not eligible for probation in front of a jury because these allegations of prior convictions are in the indictment. And if 1 or more of them were true, that wipes out a probation qualification for you in front of a jury. So that's what I think we're looking at, right, Don?
Yes, Judge.
Okay. She needs to repair the indictment.
Yes,
Can you do that in 1 week?
we can try, Judge.
Well,
I'll get it to intake today, but
thank you.
Judge, he's also asking that regardless, it be set for trial, that I be relieved so he can get to court with him.
You be relieved for what?
That I be relieved.
So he can be pro se?
No, sir. He wants another attorney appointed, so it can be resolved.
No.
With no matter.
Don Dusler, I've known Don Dusler my whole career. He's a fine lawyer. You can go hire anybody you want. But I chose him as one of my public defenders because he's competent and he represents his clients. I've known him for 40 years. And no, but you can hire anybody you want, but you don't get to pick the appointed attorneys. That's not the way it is, sir. Sir, go ahead.
I am requesting another one.
Okay, you're denied. Denied. You were entitled to a competent attorney, and he is one. I haven't heard anything to suggest he's otherwise, or that there's a problem between y'all two. That's the way it works. You can understand if it was otherwise, let's say everybody, we have 3 public defenders or 4, and then everybody decides they don't like 3 of them, then one person would end up doing 1,000 cases. That wouldn't work. But they rotate, and sometimes you may disagree with them, but I was a lawyer, private lawyer for a long time, and sometimes people didn't agree with the advice I was giving. But you're entitled to know from legal expertise what you're facing, the pros and cons. At the end of the day, it's not his choice, it's your choice on how you proceed, but you don't get to choose the attorney when it's an attorney that's appointed to represent you if the attorney didn't do anything inappropriate or unethical. Don doesn't do that. So he has a good reputation. Let me just rotate this a week so we know where everybody stands on what the defendant wants to do.
Yes, Judge, we'll get that indictment.
This needs to be, you can correct it.
It'll likely have to be re-indicted
Yeah, well, that's what they do on Thursdays, right?
Wednesdays, yes.
Wednesday.
Yeah.
Okay.
I'll do that
And
today.
We'll do this back on Monday week and see where we are on that, okay? And see if there's a way it can be resolved without a trial, and then if he wants a trial, he'll get a trial, and then it's one of the trial lawyers.
Can I speak?
It would be different from him. Yeah, you can speak.
When I arrived at the police station to turn myself in, because I realized I had made a mistake. I learned that the blue warrant had not been active yet.
Okay, hold on.
And
You're talking about the facts of the case, right?
To the halfway house.
Yeah, hold on. You're talking about the facts of the case. And number one, unless you're going to ask me to be the judge and the jury, you're going to have a jury trial if you want a jury trial. But right now you're talking about facts of the case, and I'm not the fact finder for whether you committed a crime or not. That's not what we're here for today.
I was just trying to tell you.
There's nothing I can do about change. Okay, sir, there's nothing I can do about.
Read me my Miranda rights.
Okay, all right, that's something you tell your lawyer, and that's brought up in front of the court or the jury if that isn't part of the element of the crime. But that's not anything that really I can do right now. But that's where you pass all that, then that gets brought up during a trial or doing a pre-trial hearing, and then the court or a jury would make the fact issue determination, and then your life proceeds in that direction. But right now, that's not there's nothing I can really do about what you're saying. First thing is the indictment needs to get corrected.
Yes, Judge.
That is,
Get on that.
it's clear. Okay, and then we said 1 week and see where we have gone from there. Okay, sir? Don, thank you. Don, I've got Sergio Preciado, that's reset.
It's been reset. We'll wait.
All right, friends, let's step back across the hall with Judge West.
Good morning. Are you Darius Sparks? Yes. And Mr. Sparks is charged with assault, family violence by impeding breath or circulation, and cause number 25 DCCR 0754. And what is the announcement?
Judge, I think we have a resolution this morning. May I first permission to have the name Raynella Gage called, and to see if she's in the courtroom today, then I can.
Raynella Gage.
Yes, ma'am.
Raynella Gage. Is there a Ranella Gage? If you'll call the name, please. Ranella Gage. Robert Simon.
No response, Your Honor. Judges, the record may reflect that I have reached out to Ms. Gage. I've sent her multiple letters. She did call back. She was, I returned her call. She was in a meeting that said she would call me back. She has yet to do that. I just wanted to see if she was in the court today, but I do think we have a resolution. This court will allow him to participate in the bid program, but this case to remain pending in case he does not successfully complete that, and a determination of it should dispose of it.
And how long is that program?
6 months. Should be no more than 6 months, and we could probably get him signed up the first week of July. We could maybe do a 90-day status check on how he's
I
doing.
definitely want to
if
make
he's doing-
sure. So here's the thing, Mr. Sparks. I'm going to reset your case, and what I'll do is I'll do a 90-day reset. But I'm ordering you to get signed up for that bid class at the very first available class. Because this is a great opportunity. Okay, if you take this class and do everything you're supposed to, successfully complete it, it sounds like your case is going to get dismissed. You can't get a better deal than that. But here's the thing, if you miss the class or some reason get kicked out of the class or you're not going like you're supposed to, I'm not going to put the case off any longer. It means you're going to be back here facing this case here in court. Okay. So it's very important you do everything you're supposed to. All right. Thank
Judge,
you.
would you mind still admonishing him as to the no contact during this?
Yes, so you have, as part of your bond, you're still on bond now and you'll be on bond this whole time. So you still have to follow all of those rules.
Yeah.
And one is that you have absolutely no contact or communication with Ranella Gage. That's in person, that's sending messages, that's any type of communication. Do y'all have a child together or anything like that? Okay, so there's absolutely no reason for you to contact or communicate with her. That would be an immediate violation of your bond. Obviously, the same deal that you're getting right now would be off the table. You understand? Okay, we'll see you back in 90 days. Talk to Mr. Rojas. He'll let you know. He'll get with Ms. Malfino when that class starts and how to get involved in all of that. Okay? Whitley Shepherd, it's a sentencing, Mr. Rojas.
Whitley Shepherd. Whitley Shepherd. Okay. Very fun.
Left out on that, let's make sure. Then they're in that.
Good morning, you're Whitley Shepherd.
Yes, ma'am.
And Ms. Shepherd was previously in court, entered a plea of guilty to the second-degree felony of aggravated assault with a deadly weapon. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
Not from defense.
Not from state, Your Honor.
Ms. Shepherd, when I'm reading through what happened that day, it is one of the most frustrating things. You are out there as a parent at a park where we've been having all these issues with the kids acting stupid with guns and shooting. And there you are with your kids and other kids out there displaying a handgun. I have had some second thoughts about even going along with this plea agreement, because that type of behavior, especially as a parent in front of all of those kids, is unacceptable. That's what's wrong with what's going on in our community right now. Does that make sense to you? Yes, ma'am. So if I do go along with this, I want you to understand how important it is that you follow every rule under this probation, because if you violate any, things could be very bad. And I'll talk about that in a minute. You understand Any reason not to go along that you can tell, Mr. Rojas?
No, Your Honor.
Mr.
No,
Ro-
no,
I mean,
Your Honor.
Mr.
Nichols.
Nichols, sorry, I'm reading these other names and hearing sounds, so. You've got two sons, 17 and 16, right?
I'm sorry, so you just,
Turned 18 yesterday. And then is the youngest one's a girl? They all live with you? There any other guns in your house at this time?
no.
Your kids in school? Where do they go to school? All right, Ms. Shepherd, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement. I'm going to defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes that you cannot go to Magnolia Park at 2930 Gulf Street. Can't be anywhere near it. Do you understand? Also, you can obviously not have any contact whatsoever with Myrtle Reggie, Jeremiah Lee, and Soraya Reggie. Do you understand? That's in person, but that's also sending messages or electronic communications or anything like that. You understand? You cannot have a firearm anywhere in your house, in your car, at your work. You are not allowed to be in possession of a firearm, and you can't have one in your home, even if it technically belongs to someone else. You understand that as well. If you do everything you're supposed to on this probation, this is an amazing opportunity because you don't have a felony conviction. And at the end of the probation, you can, if you're successful, the case is dismissed and you never will have a felony conviction. But the other side of that is if you violate any condition of probation, you can be brought back in here, found guilty of the offense. And I have that entire range of punishment to look at, which is up to 20 years in prison. It's not just the 5 years that you're being placed on probation for. It's the whole range between 2 and 20. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Luciano Richard, the sentencing. Good morning, ma'am. Are you Luciano Richard? Yes. And Ms. Richard was previously in court, entered a plea of guilty to theft of property with previous convictions, a state jail felony. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. State has charged.
Any additions or corrections?
Not from the defense, not from the state judge. We'd ask that the court follow the agreement of the parties.
Thank you, Mr. Coleman. Ms. Richard, I'm going to follow your agreement. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, place you on probation for 5 years. You're ordered to pay a $500 fine, and you're also ordered to pay $220.46 in restitution and to follow all of the other rules and conditions of probation. If you do all of that, this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the case, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition, you'll be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison between 6 months and up to 2 years. Do you understand? 5 years is a long time. In fact, if you take care of everything you're supposed to, get that restitution, your fine paid off, do your community service, it is very likely that you could get off probation even earlier than that, but that's up to you. You have to do everything right, get it all taken care of early. And then I sign early dismissals from probation all the time. I mean, you have no felony history. There's no reason for you not to get this taken care of and get off early. Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up when she's ready to go over your paperwork. All right, good luck to you. And then I'll give you a minute to go talk to Mr. Pena. Mr. Burbank, you've got John Martin. Here in. That's the third one today. It's okay. I know. Good morning.
Good morning.
Good morning, sir. Are you John Martin? Mr. Martin, in cause number 25 DCCR 0583, you're charged with the 3rd-degree felony offense of injury to a child from March 15th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Burbank that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, which means it's a type of probation where you don't have a felony conviction. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter that plea. Do you understand? Do you want to reject that offer and have your case set for trial? And is there any reason to believe that offer would change or go down, Ms. Malfino?
Not today, Judge. It's my intention to send out trial notice this week. Mr. Burbank and I have discussed and reviewed CPS records in this case. We do have a plan going forward. Or to pre-trial if something were developed, we'll let you know before that.
Okay, perfect. So unless something changes, like Ms. Malfino said, then typically after today, I will not accept a plea agreement once it's on the trial docket. So stay in touch with Mr. Burbank. If something comes up and you guys get some other information, it works out, we can take care of that well before that trial date. Otherwise, we'll take care of your case on the trial date, okay?
Thank you.
All right, thank you, Mr. Burbank. Yes, sir. Yes.
Yeah. You want him up here? He's there.
You can just tell me.
He wants to do lawyer.
Okay, so Mr. Pena will appoint someone new. If you can come up to the clerk, she'll give you that information.
Excuse you.
Yes, thank you.
Okay, friends, let's head back up to Michigan and Judge Prill, new contestant there, and that will probably about finish out our day. We'll see.
Randall Lyles Jr., file 267430 FC. As well as 7432 FH. 7430 is scheduled for sentencing. 7432 is set for a miscellaneous hearing. Mr. Lyles is present, represented by attorney Michael A. Borowski. People are represented by prosecuting attorney Timothy J. Rakowski. Back on April 13 of this year, the defendant entered 2 guilty pleas to criminal sexual conduct 1st degree. Ms. Karen Evelyn prepared a pre-sentence report dated June 8, 2026. Mr. Borowski, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Any additions, deletions, corrections, or objections?
Nothing of note, Your Honor.
Anything regarding the guidelines book?
No objection to scoring the guidelines.
All right. Mr. Lyles, do you agree with all that?
I do.
Mr. Rakowski, any objections to the report as well as guidelines?
No, Your Honor.
Thank you. Borowski, anything you'd like to say on behalf of your client before the court imposes sentence?
Yes, Your Honor. Mr. Lyles makes no excuses for his behaviors. Just mitigation and how this. But Mr. Lyles did grow up with a terrible childhood, Your Honor. He went through a terrible ordeal. And he's been through a lot. Based on my conversations with him, it was a childhood of abuse and traumatic. He wishes he would have gotten treatment sooner. He is currently on depression medication. So he has sought anger management treatment and treatment to deal with his behaviors. Mr. Lyles and I have discussed the sentence recommendation. You know, Your Honor, at this time, we ask that the court sentence Mr. Lyles at the low end of the guidelines here today. Thank you.
You're welcome. Mr. Lyles, is there anything you'd like to say, sir?
Yeah, I'd like to apologize to the victim. Also to the parents of the victim. I don't know why that happened. Since we had the tablets, I've been doing courses. I've done 13 courses a week in the last 3 weeks. That's 39 courses total. How to be a better person and how to deal with situations that were in my past. My childhood was not the greatest. I remember my mom coming home from a bar saying she was sexually assaulted. I remember being in the bar at the time she was drinking alcohol. My stepfather at the time was not sexually abused, but verbally and emotionally and physically abused us kids. He wouldn't do it to his own son. My cousin sexually harassed me, sexually assaulted me, I should say, for 5 years. And I reported that to my mom and to my stepdad, and nothing ever happened. They just ignored it. I feel like every charge I've got was because of the past. Like every charge I had was I was in a relationship. Like I don't have any criminal history other than being in a relationship, with family, with my significant other. I know I should be punished. I wasn't thinking that it would be prison.
Anything else, Mr. Lyles?
Nothing.
Mr. Rakowski, anything on behalf of the people? This is a victim's rights case. For the record, father of the victim in this case is appearing via Zoom.
Yes, Your Honor. I have 2 letters I wish to read to the court. Dear Honorable Judge Prill, I am writing to court as the father of Mackenzie, the victim in this case. Because of the deeply personal nature of these events and the emotions they continue to evoke, I've had to ask Timothy J. Rakowski to read this statement on my behalf at sentencing. My hope and my prayer are that with time, my family can begin to heal and regain a sense of normalcy. I especially hope that my children will be able to move forward without enduring lasting effects because of the abuse that has occurred. This case has had a profound impact on my entire family. As a father, knowing what was done to my daughter, Mackenzie, has caused immeasurable pain and suffering. The emotional toll on our family has been significant and enduring. It is my sincere hope the court will deliver justice for the harm that has been inflicted. I respectfully request that no leniency be granted in the sentencing of Lonnie Lyles. I ask the court impose the maximum sentence permitted by law in recognition of the seriousness of the offense and the devastating impact they've had on my daughter and our family. Sincerely, Mr. King. From the victim, dear Judge Prill, I do not like it that Lonnie did everything to my family. After everything Lonnie did to me, I did not like Lonnie hurting my family or me. After what Lonnie did, I now hate him a lot after he hurt me, my sister, my family, my dog. I am now very mad at him. What he did made me feel less confident and to trust people less. I would point out that this case, that there's a failure. One of the failures is by the state of Maryland, because as the report indicates, Mr. Lyles had done this to a different family member and received a sentence, but they suspended it. He should have been in prison in Maryland for this type of behavior, but he was not. So it's unfortunate that they failed because as a result, we have another victim of a criminal sexual conduct. Your Honor, I would ask you adopt the various recommendations. The sentence we'd ask for the court would be 23 years and I believe it's 23.75 years. That's what we're asking for the court for a sentence. We believe it's appropriate under these circumstances. We're also asking that restitution be left open, Your Honor.
Very well, thank you. Question for the probation agent. Condition number 2, would that not be a probationary condition if the court sentenced to prison? How can the court sentence?
Yeah, we could do that.
You can do that.
They can, when he comes up for the time of parole, they can add that condition that he not have contact with that individual at that time.
Very well. Thank you.
You're welcome.
These, actually, frankly, all criminal cases currently are subject to review by the Court of Appeals, Michigan Supreme Court, and even sentencings within guideline ranges are being reviewed to see if they're proportionate. And the court has considered a lot of factors in fashioning an appropriate sentence, including obviously punishment, deterrence, all the standard stuff, but also the defendant's condition, chance for rehabilitation, a number of factors. This is an unspeakable crime. 2 counts upon a young child, first degree, frankly, unspeakable and unforgiving on behalf of any victim involved or victim's family. What's sad about it is, and Mr. Murkowski made reference to this, is this occurred previously in the state of Maryland, and the defendant received basically his sentence was suspended, didn't have to serve the time. And obviously from that time moving forward, it would appear that there would have been time for rehabilitation, time to address any other concerns. A lot of factors that the court could have looked at, and that was back in 21. First degree assault, 3 years probation, served 10 years, suspend all the time served for 214 days. That was in the state of Maryland. So the court does take into account the defendant's upbringing. The court takes into account all other factors contained in the pre-sentence report. And it will be the sentence of this court relative to both counts that the defendant register as a Michigan sex under E either directly or through another person, nor be within 500 feet of her residence, school, or place of employment. Crime victim's assessment of $130, attorney fees are waived. He's to submit to HIV testing and complete counseling associated with that, and waive confidentiality and allowing test results be released to the probation office and court. $136 in state costs will be ordered. He is to submit to mandatory lifetime global positioning system monitoring and comply with all the requirements of the system as directed by the field agent or managing law enforcement agency. He's also paying any costs associated for loss and damage to monitoring equipment at rates established by the DOC. $141 will be ordered for reimbursement of HIV STD testing. Restitution will remain open in this file as well. And it will be the sentence that the defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of 23 years, 9 months, to a maximum of 60 years, credit for 143 days previously served. My duty to inform the defendant, he has right to seek legal appeal. Provide counsel of his own choice. Court will assign counsel for proposed expense. He's to initially receive questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. defendant is remanded to the custody of the sheriff. Court is in receipt deputy of notice of right to appellate review of the request for appointment of attorney form. It's been executed by the defendant dated today's date. Off the record in this file. Status of the other files.
We've prepared an LA file for another file pursuant to the plea.
Well, I guess we're not going to hear about those other files, are we? But he's pretty cooked. What was it, 23 to 60 years? So that should about do it for him, I would think. And that will do it for us for today, but we will be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Thank you all so much for joining me today. I hope you had fun. The wisdom that I leave you with for today comes to us from Marcus Aurelius. Waste no more time arguing what a good man should be one. All right, my friends, we will see you tomorrow. Go have yourselves a good day. Take care. God bless.